as an I for releasing check.
Hmm?
Releasing check.
Releasing?
Check. Passing the court's order lodging. Or directed the insurance company to check and accordingly deposited lodging. Government. On next we still lodging. Some urgency is there.
Urgency.
Money is always urgent lodging. The accident occurred in 2017 lodging. Thereafter 2003 lodging. Our part. Immediately is not indeed case. On two still.
14 May. 14 May.
It,
No, everything is going to fall. Show me some good reason otherwise. 14 May. It doesn't have time to see. Later on, I can fix it tomorrow also. It won't reach.
Item number 13.
Really? You want adjournment?
There is lordship another RSC filed by the present respondent arising out of the same judgment on the lordship finding of fixed in matter together loss.
So you give it to the appellant service. What is the number of the RSA?
111 of 80.
The infinity is connected with RSA number 18 oblique
80.
200.
11 of 1080. Problem good.
Wait, please, Your Lordship. Lordship, I beg to mention item number 38 on behalf of R. Sharma, Your Lordship. Lordship, his father has passed away on 27th of April, Your Lordship. For that, we could not be present before this honorable court, Your Lordship. If Your Lordship allows, the matter will be adjourned, Your Lordship.
What is the matter about?
Lordship, I for what? I for 1638, as per the record, Your Lordship, I've seen this one. It's for substitution of the legal peers, Your Lordship.
So, it allow it. Appeal.
Lordship, I
Take a fact. If I don't allow it, then I let you.
for motion item 3954.
Yes, what happened? No file. No junior. No file. Sense given. Yes, tell me. Yes, tell me what is your case?
Not whatever I have done.
submitted in the last hearing. Madam, so this is another code of civil procedure. My lord, the issue should have been made before the leading arguments. There are no issues on that aspect of the matter. And my lord, my lordship comes to
You mean to say that these cases, these type of cases go like a civil suit?
my lord.
Show me,
$2. My lord,
show me anywhere, any position.
in the General Process Act also, section 3, subsection 15, my lord, defines the district judge. Now, once the matter is referred to district judge, now it is a civil court for all purposes. And so when evidence, because it's not a summary procedure.
That's somebody puts.
Under
There are many judgments also. Recently also, a judgment.
my lord, but the evidence has to be there after the framing of it.
There is no issue, plain requirement of framing the issues.
And my lord, the second aspect is, my lord, the multiplier of H should have been.
Right.
My lord, in the calculation of the compensation, multiplier of H should have been applied, my lord, in the computation of compensation. In some cases, my lord, 12, 13, in some cases 12. And but in the deposition also, my lord, in the cross-examination of the forest officer, he says that he has given this on based on presumption. Right.
Are you challenging on the question of limitation?
Limitation, my lord, what has happened? We have in the written statement, my lord, we have a specific denial on the issue of limitation, that the suit is barred by, that the suit is barred by limitation. Page 57.
Read,
First of all, my lord, may kindly come to page 56, my lord.
or come to your objection. As you raised it.
My lord, at page 36.
Page 29. That the present miscase is barred by limitation.
25, my lord. That's page 25.
25 is this petition. Why you are coming to that? You are coming to your objection at page 29. Not prepared properly, Mr. Sharma.
Oh, my lord. 25, my lord.
You want further time to prepare another day.
My lord, just a resignation.
Paragraph 3. Page 29.
I'll just. But at page 29, paragraph 3, where the present miscase is barred by limitation.
Why? Why?
So my lord, what has happened is that they have come to the court after 3 years.
After 3 years, it's what? Section 137 only on when it comes to 3 years.
My lord, 3 years, my lord,
When the right
on
to
the-
apply accrues.
on the point of limitation, my lord, no issue there. That is my.
Not necessary, but the question is, have you ever agitated that? There's no question of framing of issues out there. Now, have you raised that issue out there? Once you have raised that issue, now tell me, I'm in 227, what is the ground?
My lord,
I'll finish it.
in 2015, my lord, in 2015, they had accepted the compensation without any protest. And in the end of 2018, my lord, they filed these cases before the London Additional,
These cases were filed in 2017.
but 2017, my lord. And by their own,
So what is your fact for that? That it is barred by limitation? Kindly see page 34, Roman 2. The answering opposite party estimated the surface damage caused to the petitioner with the help of the Revenue Department, Hailakandi, as per the prevailing government rate from 2012 onwards, and the payment was made promptly just after removal of air in the year 2015. And as such, the question of payment of interest does not arise. So this petition was filed in 2017. Then, where is the question of limitation? And as such, your counsel who appeared before in that court also must have come to a finding that these type of questions should not be raised at all. You must have been also ashamed by taking up that thing.
so my lord,
When you filed this written statement also, it was within the period of limitation.
my lord, one of my contention is that, my lord, the multiplier
What multiplier?
of which should have been applied. my lord.
How much? What is the multiplier? You have not given any evidence.
Evidence was because
No, the court had fixed up for evidence. Why you are saying that there is no evidence? When the other side has given evidence, a chance was given. I am making a statement at the bar out here that there was no chance given, then I'll call for the records and then look into it. And if it is false, then obviously then we'll take action against you. As a lawyer also. Make a statement in the bar, I'll record it, that there was no chance given to give you evidence. Don't come up with these type of things. No thing.
my lord, what has happened by their own deposition. The revenue official.
You had the right to cross-examination and you cross-examined them also.
Under the cross-examination. Whatever this there, come to the court, there was no seal, no official document.
No. In the cross-examination, they say, when they were asked out there, he said that this was attested by the DFO. All these things have been done. Then there was some overwriting out there, something to that effect. He says that this is otherwise legally permissible, everything is done, but it does not have that signature. That is it. So how does it matter?
And
Why didn't you give any evidence of 2012?
in a particular statement, my lord, at page 56, this is the Abu Hussain Majumdar, he is the in charge for
Yeah,
Hailakandi.
I'm referring it to that, the cross-examination, see there.
I have stated that the market price of different kinds of fees may be higher than the mentioned in the schedule is only on my presumption. Exhibit 2 is attested copy. It is not a fact that Exhibit 2 is not admissible in law. In category E, at serial number 1 in the table, there are some handwritten words, but there is no signature of any officer authenticating the same. Now, my lord, he has presented everything only based on presumption.
No, kindly see what is exhibit 1.
Exhibit 1 is the forwarding letter, a royalty schedule dated 23/8/2022. Exhibit 1 is the signature of General Director so and so, Hailakandi Division. I've also got the copy of the notification dated September 1, 2009, issued by the Commissioner and Secretary Government of Assam Employment Department, pertaining to different kinds of fees, their lifespan, their prices, royalty, etc. in details. Exhibit 2 is the notification. Our DFO sir has attested the said notification. His Exhibit 2, 1 and 2 are 11 are his signatures. I know his signatures and still because I work under him. The market price of different kinds of fees may be higher than the mentioned in the schedule. The exhibits 1 and 2 are lying with the Miss PG case number 8 of 2016. Then, no, my lord, a proper competition. That is my.
No, why didn't you give evidence? I'm asking you, why didn't you give evidence? Show me a document to that effect out here. We are in 227. Show me a document that it is less.
Look, these exhibits, my lord, are of 21, 22, my lord. And our assessment happened in 2013, 14. There would have been a price difference. You know, by 21, 22, there would have been escalation. Prices would be
Exhibit
higher.
one, one C is a forwarding letter dated so and so. Exhibit one is the signature dated. I have brought the copy of the notification dated 1st of September 2009, issued by, that is the basis. That, we are making that submission. Show me any document to that effect. Let us see how the trial have looked into. Whether the compensation paid was adequate or not, page 75. And let's see, page paragraph 91. In support is where the petitioner have reduced the evidence personally and through the officers of the agricultural officer and the forest department who have submitted the showing the prices and yielding capacity of various agricultural, horticulture, so and so producers for the year 2011-12 to 2021-22, particularly for the year 2013-14, which is the relevant for the instant case. In the case of the hand, it is admitted by the opposite party by way of written statement that the plants and trees like so and so, so and so, so and so, so and so, so and so belong to the petitioner was damaged with the drawing of the player. However, pay the sum. However, the opposite party did not pay the actual computation counting the yielding capacity. According to the petitioner, her little nuts were cut down at the age of 12 years. If this tree was cut down at the age of 12 years in view of the expert opinion revealed in Exhibit 3, at so and so, it is clear that the said little nut could have been yielded fruit at least for another period of 8 years. Similar is the situation for other items also. If the lifespan of the other items are taken into consideration from the price list produced by the competent authority PW1, then also it appears that the OP did not pay any actual damages here. Thus, it's clear the year deprived here. However, the trees and the unspecified firewood like potato, so and so, there is no price list available in here. The petitioner side has also failed to produce any evidence to show the net production per year unit. As such, I am of the considered due to hold the petitioner claiming enhanced complaint in respect to harvester has failed to prove the inadequacy in respect to the damages for potato, avaru, and so and so. Thus, whatever compensation was paid is good. Then what better order can you get?
Why
You should
not?
be happy with it.
And again, at the same page 77,
Timber crop.
issues number 4 and 5 have not been decided.
What?
Issues number 4 and 5. What
Whether
the
the plaintiff is entitled to the relief in particular enhanced
competence
manner
claim
as
for-
claimed for and what relief the plaintiff
you're
is
entitled-
in view of the, what is this? Paragraph 11 is the decision.
in view of decided preceding issues, I am of the considered opinion.
No, this is the decision.
Does not particularly say, my lord, that 4 and 5 have been
Let us record this type of submissions and dismiss it. Now you have taken the time of lot of lawyers. So I think 1 lakh each for each case cost should be imposed for this. Other lawyers, when you go to the Guwahati High Court, lawyers, so that they can be also compensated for being not able to do their cases in time. Unlike, how many cases? 7, 6 to 7 lakhs.
why not they hear the matter again on Thursday?
Thursday again. It becomes 14th. This is judicial time. Isn't it? High Court Counsel, Mr. T.J. Mohanto. Huh? You are the flag bearer of the High Court advocates. Now tell me, am I really not spoiling the time of this court? Yes, madam, I am just waiting for you to dismiss. Otherwise, I would have said that none appears for the respondents.
Why not they hear it on Thursday?
What?
Why not they
It
hear
is
it?
no Thursday debates. Thursday is too much. There's nothing except the pathetic plea that 227 should be exercised. Isn't? We can do only one thing, save the judicial time of the trial court and say that you make the payment out here and then ask these people to take it and stay till that day. Matter is already parted before me. So on the next date also it will come, and then I'll ask all these people to take the money. Not Tuesday is not necessary. Okay, we'll hear again. We have no other problems. It's already parted. Eh? I've dismissed. Show me, show me. I've dismissed similar cases.
Madam, that was under, with all respect, that was at the point of limitation, right? That's only in the point of.
No, here to limitation does not arise. In that case, these are the cases where he raised the issue of limitation. I said that the right to apply when accrued, because 137 only comes when the right to apply accrues. And if you read 116.3, it says if any dispute arising concerning the sufficiency of the compensation to be paid under section 10, it shall be applicable. So here the dispute has to arise. Once you make the payment, there is no dispute. The dispute will arise only from the date on which I request you and you don't accept. Isn't it the dispute then? No? In your case, there's that case also is not.
I know, deposit the amount with the registry, madam.
Why do you want this court to be the executing court?
So, madam, ultimately, the money will go to the district judgment.
Because why I'm concerned is this. You have been asked to pay at the rate of 6%. It is after all public money. Why you are delaying it? Why you are not making the payment? You know you don't have a case. You are just filing the case just for the sake.
Madam, as submitted earlier, madam, they are subject to this court order.
You should have immediately deposited the money before the court.
We cannot escape that. We cannot escape. We have to pay. Ultimately, we have to pay the enhanced amount.
And Mr. Sharma, you are also aware, when the court has decided that multiplication factor is 8 or whatever, that he has taken 8 only for these betel nut trees. Others he have taken it separately. It is only for the betel nut trees he has taken 8. Others he has given his, on the basis of that whatever evidence was there. So he has given it. Now the question out here is, this is a finding of fact unless you show me a perversity would happen only in a case when you have proven evidence to the effect that this is less which have not been considered. So under such circumstances, without a perversity, this court cannot touch. We are in 227. I remember that. So the question of jurisdiction does not arise.
I don't think here is, within 2 weeks, we'll.
No hearing. This is not a case for notice. If I issue a notice in your case, Mr. D. Chakravarti on the backside will come up and say that day in order 21 rule 29 application, you could have at least issued the notice and not dismiss at the stage of motion.
Madam, simple direction that we have to pay the amount, then my lord.
That is also I will. 227, I can't do all this. I have to only dismiss or allow. I'll issue a notice. And there are some other cases also. There's some stay order. So get those cases also together and finish off those cases also. There's some stay granted in some other cases.
Apparently, my lord, come to my notice yesterday that one case has been allowed, my lord. And that is because your lordship's earlier judgment dismissing those batch of petitions were not informed to that court. Otherwise, the court would have been bound to an earlier order.
No, without any protest. This is the most pertinent thing. If you are saying without any protest, you have to prove that document. Where's your evidence? And where do you find in section 16 a parameteria provision to which is there in the first proviso to section 31(2) of the Land Acquisition Act. There is a bar that a person concerned who have received the money without protest cannot file a reference. If you see section 18, it categorically says a person who has not accepted the award can file a reference. Here there is nothing. Here it says only a dispute.
All the petitions may be clubbed together and
We first finish off these 27. When we finish off these, today I would not.
here we'll deposit the money.
No, no, not like
And
you do.
my
You
lord, we have
deposit it.
all the petitions.
No, 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 you deposit whatever money out there you want. Yeah. What are the other matters? We list those matters also. Huh? PRP 37. You are the lawyer.
Madam.
How many cases you have filed and got some stay on?
Four, five.
Okay, give the dates, the numbers. While hearing the matter from Mr. Ashwama, the Learned Senior Counsel has also brought to the notice of this court that there are similar other petitions also pending wherein notice has been issued. So taking into account the above, list the instant matters again on. Give me a good date when you want the dismissal. 7th of May.
7th of May is a holiday, my lord.
Lucky. Chat is safety. 9th of May.
Not, my lord is going to hear the matters, so my lord,
These type of matters doesn't require us to be on a Thursday. People will laugh. I've already booked up on 13th, 15th. Okay, on 14th of May. On 14th of May, along with next matter, give the list.
my lord,
Yes, yes.
If
Mr.
that
H.
happens, belong-
R. Sharma, assisted by Sons. Yes. Huh? 14. Well, on 9th? 9th? You know, 16 happens to be the good day. For motion.
Appellate.
At our order, deal with the thing. You give the list, Mr. Sharma. You give the list. You. Yes, Mr. Samondo, what are you challenging?
I'm challenging the order dated the order dated 12/3/2025. Very only very limited purpose, limited ground, my lord. The lordship kindly see, defendant, my lord, defendant submit a list of witnesses. And that was, they were examined and thereafter they filed another application.
Yes, what is that?
So they have filed an application. Already they have list of witnesses they have submitted. And that is completed, they have examined. Hereafter they file an application. So because someone left, my lord, yes, they can do it, but by way of my lord order 6213.
1A,
13.
1A,
As a defendant witness.
1A.
When your lordship can see the, then what to do, my lord, in the application.
1-3 will only come into the
What?
picture when, if in the list of witness, these people's names are not being given,
No,
then
yes.
they cannot call without the leave of the court.
Fine.
But 1A is another provision which gives the power, which gives liberty to heir to bring it by themselves.
Here, my lord, your lordship can, your lordship can see their application. Page 26.
What is that? Where is the application?
Page 26, my lord.
Page
26.
pleadings of the parties to the suit reflect that the deposition of the human is very much necessary here, which the actual occurrence for the purpose of arriving at the just decision. Then,
Therefore, wherefore the Honorable Court may please to allow the appellate party to interest under the call for the witness of the defendant. So why, my lord, as per my lord, you will appeal go by the clause.
no, they cannot call for. With this application, the court cannot call
My lord,
someone.
my lord, no, they wanted to cite, his name was not in, at least, my lord, if your lordship go by the one subclause 3.
Why should I go there? When was order 16 rule 1A is there? Read. Order 16 rule 1A.
Subject to the provision of the sub-rule 3, rule 1. Any party to the suit may, without applying for someone under rule 1, being any witness to give evidence to the produce document. But he wanted his witness of the defendant, but defendant side. So that's why, my lord, why he is not been mentioned in the witness list of witnesses, that is not been reflected in the application. So my submission that, my lord, is since he want to examine as a witness of the defendant, so my lord, he has to, my lord, file this application, my lord, under subclause 1(3), my lord. 1(3), he has to make a statement that why he was unable to, his name was included in the list of witnesses. That is not reflected here, my lord. The lordship kindly see in their application, not a single line there. The why his name was, that name was not reflected in, my lord, their list of witnesses. So without this, my lord, how this one is meant? So that is my only question. Very clearly, my lord, the court may, for reason to be recorded, permit a party to call a witness by summoning to the court on otherwise by witness other than those whose names were appeared in the list of reference in subsequent clause rule 1. Such party shows sufficient cause for omission of the to mention the name of such witness in the said list. So not a single line is there.
Which is the law which stops him from reducing evidence.
No, I'm not stopping him. I'm not stopping. But my lord, when there is a procedure that has to be followed in that application, my lord, at least, my lord, that line should be there. Why is this name was not included in law provided that, my lord? Since law provided.
No, there is judgments to the effect in respect to order 16 rule 1A. Order 16 rule 1A categorically says that it is not required.
No,
The court, the thing is like this, why it is made subject to 1(3) is because of the fact that he cannot, without taking the permission,
my lord.
without taking the leave, or without explaining properly, he cannot call that witness to the court.
My lord.
But if he does it for himself, he gets his evidence on affidavit file, whatever may be, then it is okay. That is order
No,
16.
here he said, but he's not a court witness. He said that for defendant side, my lord.
Understood. That is why I am saying
No,
that is
why, my lord,
permissible.
It don't have to be recorded, my lord. That why his name was not reflected in, my lord.
That is not required. Therefore, it is why it was made subject to rule 1(3). There are judgments to that effect, Mr. Mohan.
My lord. No, in that case, my lord, his application should be under what? Immediately under 1 rule 1(3).
No, 1A. In fact, he doesn't even require.
No,
He can
court
very well
go
file
ahead
the
and
evidence on
inform,
affidavit.
please.
It is a different thing. You may very well say that after cross-examination, everything has been done.
Fine.
Now he wants to file the evidence.
Fine.
in order to fill up some lacuna or other things, whatever may be. That is another aspect of it. But he has a right, without even putting his name in the list of witness, to bring him, if he does it by himself. This is the law.
But my understanding is that, my lord,
That is why in 1976 this amendment happened.
yes, 1A. Subject to the provision of sub rule 3 of the rule. That is addition. That is addition.
Any party to the suit without applying for summons under Rule 1, bring away. So he has to bring him by self only. He cannot ask for summons. Now, if 1 tree is had, then he has to only, just for example, an official witness.
My
He
lord,
cannot bring him
my lord,
because he cannot be his witness. So he later on cannot without 1 tree being done.
my understanding was that, my lord, that 1 3, my lord. 1 3, yes.
1 tree, if he wants this person, just for example, if he wants the court to call him, no, he cannot.
At any time, my lord.
No, 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 no. The defendant may very well ask
Yes.
that he is my witness. To kindly let the court issue summons. See, order 16(1) kindly. See. On or before the date as the court may appoint and not later than 15 days after the date on which the issues are settled, the party shall present in the court a list of witnesses whom they propose to call either to give evidence or to produce documents and obtain summons. Now kindly say, and obtain summons to such persons for their attendance in the court. So, for that purpose, here you have an end. And obtain, see, I need to give evidence. This is an evidence given under Order 16(1). To produce document under Order 16(6). And obtain summons. So they will issue the summons to such persons for their attendance. A party desirous to obtaining any summons for the attendance of that person shall file in the court an application stating their purpose for which the court, for reasons to be recorded, permit a party to, whether by summoning to the court or otherwise, any witness other than those whose names appear in the list, so and so, if such party shows sufficient cause for omission to mention the name of such witness in the list, subject to the provision here, summons referred to here may be obtained by so and so. 227 notice. What to do? Dismiss, withdraw, which one?
My understanding was that, my lord, the 1 3. That is why.
There are judgments
And-
also. You have another case. You would have come up with that after the evidence of this, he is actually required to file his examination in chief of this witness earlier, which he did not. We had another case, but that is not a case here. Why should I
There is not.
expand?
Okay, Mr. T.J. Mohanta, the legislative counsel, by 74 submits that as instructions not to press the instant petition. Taking into account the above the instant petitions, that's true. But
Item 2.
Where is Mr. A.M. Borbunia?
Item 2.
Yes, what is this? What case you have? No case. Yes. Tell him. We don't have a case. The request of the learned counsel for the petitioner matters in withdrawn to magistrate in 2 weeks. Pray. Yes, what are you challenging?
The order when I look at there is 8E1.
Page 81.
Contesting the parties are duly represented by the learned. Is fixed for order on petition number so and so, which was filed by the defendant side, praying to reject the documents marked as exhibit 3, 4, 6, 6, 1, Roman 2, Roman 3, Roman 4, Roman 5, and 7 as the said documents were not submitted at the time of filing of the suit or at the stage of the documents. Are the learned counsel for the plaintiff side who has submitted by the order dated 7/9/2023, they had obtained permission of this court to file this document in this court by taking of the said documents from the miscase record number so and so. Therefore, the prayer of the defendant side should be rejected and the said document should be accepted in evidence. Peruse the case record. Upon perusal of the said order dated 7/9/2022 to the court, it is clear that the court had allowed the plaintiff side to take off the documents which were listed as per petition number so and so from miscase. It appears that only document marked as exhibit 3.
Why you are challenging after 7 months? Why? Not 7 months. More than that. Why?
There some certified copies of the applied here. But this certified copy.
Certified copy of this order?
No, but the records were not. Yeah,
Why do you require the report?
because the records were not so.
This
Visible.
certified copy you have taken on 3/9.
No, then the copy of the other record, but it was not legible.
Not legible, none of the documents which you have filed with the
Then we have
certified
typed
copy.
it.
None of these are certified copy before this. Why you making that submission?
No, the copy, the certified,
Show me a single document other than the certified copy, which is a certified copy.
so the certified copies are of this, the petition is of 3/9.
You have
3/9
taken the
petition.
certified copy on
These
3/9. Why you are approaching on 9/4?
No, some documents, which were,
And what happened on 13 and thereafter on 13/8? After that,
after that, nothing happened, but till the cross examination has.
why? You are taking time. The evidence of your plaintiff should be closed. I don't see any good reason for you. Why didn't you file an application before the court for seeking leave?
True, my lord. That is,
Then-
my lord, that application which they have filed earlier on 7/9, my lord, at the document stage, my lord, that was for taking up some documents from the miscase, my lord. But these are not the documents, my lord. Lordship will kindly
No,
see
you
the
made a false statement before the court. When they objected to this, you stated that you have taken the permission from the court
No,
for all these documents. This is
The-
what is being heard the learned counsel for the plaintiff who submitted that by the order they had obtained permission from this court to file the documents along with this in this case. This is the observation.
no, that,
That-
that order
But
is there.
when the court
It-
found out that no, it is only exhibit 3.
It-
Otherwise, all exhibit 6, 1,
That's
4,
what
6,
is correct.
7,
My lord.
nothing
Page
is.
58, my lord, look at.
Why on earth have you not sought for any permission out there then?
Your lordship, kindly see page 58. That is the order of 7/9/2022.
Page?
Page 58.
This is also not a certified book.
Written one, it's typed there. See?
Where is your petition?
Now,
One, two,
lordship will
three.
kindly see page 55 with my petition. Lordship will kindly see page 57. The list of documents which were submitted. The documents from serial number 1 to 8 are the documents which has been objected to for on being exhibited. These are not the documents which has been taken out from the this case one. Serial number 1 is exhibit 4. Serial number 2 is exhibit 6. Serial number 3 is exhibit 6 Roman 1. Serial number 4 is exhibit Roman 6 Roman 2. 5 is Roman 3. 6 is Roman 4. 7 is Roman 7. Roman 5 and 8 is exhibit 7. These are the documents which original were submitted at the documents thing. Your lordship will find that, my lord, page 59 is my evidence on affidavit. Page 60, exhibit 4, my lord, will see the Radgaura certificate 10/1/2018, my lord. That
Mr.
is
Counsel, Mr. Counsel, kindly come to page 64.
64.
Exhibit 6
Well,
is the RTA application.
Well.
RTA application 6-1, certified copy of the counterfoil of the correction of the death certificate.
Well.
The written statement filed by ER, death registration ER. Which are these documents here?
my lord,
And kindly come to page 55. Which are
page
these documents?
57.
Huh?
Page 57.
57, no, I'm not on 57. This is of 2023 document.
Well.
I'm not on these. I'm on these, page 55.
Page
This is,
55 are not
no,
objected, my lord,
page
for
55 is the application.
No, 55 are not the documents which are objected on being exhibited.
Huh.
50,
Then?
57, my lord, okay.
When did you submit this?
This is 7/9/2023. On the date, my lord, when this application was filed.
That application could not have been filed because this is dated 7/9/2023.
The-
Your application is of 2021.
Application is also 7/9/2023, page
It
50,
can't be.
page 55.
Page 55 is again dated 7/9/2023.
23.
Your miss case is of 2021.
Yes.
How
No,
can it be?
7/9/2023 was the date fixed for documents. On that day,
No. I'm asking you, did you file these along with the plaint?
No,
That's it.
it is,
And there was no permission given for
Yes,
that. And
yes,
this
yes,
is stating that in, kindly see the order of 7/9/2023.
yes,
Seen petition number 1343 filed by the learned counsel for the year stating that in the connected miss case number, they filed 7 documents. So you filed these 7 documents in 2021.
these 21 documents,
Where are those documents which have been filed?
these
These are not the documents which have been filed along with the miss case.
so these documents are also not exhibited.
You kindly see this page 55. Page 55 says about these documents 1 to 7, which
1 to
are
7.
not 1 to 61, 62, 63.
So,
Kindly see these.
yes, well,
What is your prayer? It is therefore prayed that your honor may be pleased to pass necessary orders to take off the documents detailed above,
case record of
form the case record of so and to keep it. Now, these are the documents, and these documents are not exhibit 61 to 6A. Chalo.
exhibit 61 to
No, this is
65.
a case for dismissal.
Okay, just one
Heard
point of one.
Mr. No, heard Mr. P. Kaushik, the learned counsel appearing on behalf of the petitioner. Mr. The supervisory jurisdiction of this court have been invoked to challenge the order dated 13/8/2024, passed in title suit number 5/2021, whereby the learned court of the Civil Judge Senior Division Lokhimpur, North Lokhimpur, hereinafter referred to as the learned trial court, had had not accepted the documents filed along with the evidence being exhibit 4, 6, 61, 6, 62, 63, 64, 66, 65, and 7, as no leave was sought for by the petitioners who are the plaintiff in the suit. In terms with Order 7 Rule 14.3 of the Code of Civil Procedure 1908, for short the code. This court have duly taken note of the impugned order of the person. At the outset, this court finds it very pertinent to mention that the order which have been assailed in the instant proceedings is an order dated 13/8/2024, passed in title suit number 5/2021. The instant application was filed on 9/4/2025. Although the period of limitation, the Limitation Act 1963 would not apply. But however, there appears to be no reasons assigned as to why there is a delay in filing the instant application challenging the order dated 13/8/2024. After 8 months, after almost 8 months, that too, when the suit is at the stage of evidence. Mr. B. Kaushik, the learned counsel appearing on behalf of the petitioner, submitted that he had to obtain the certified copy. The said submission appears to be not correct, taking into account that the certified copy of the impugned order was taken on 3/9/2024. Apart from that, in the instant petition, there is not a single other document which is a certified copy. On this ground alone, this court, the instant petition under Article 2 to 7 of the Constitution ought to be dismissed, is required to be dismissed for delay and laches. Be that as it may, this court further have taken note of the order dated 13/8/2024, and there is no error committed by the learned trial court in exercise of its jurisdiction. Considering the above, the instant petition stands dismissed.
Liberty to file
No.
a leave application.
You should have first asked for this.
Item 4.
Should have first asked me that kindly give me the liberty, let me go. I want to withdraw with liberty to file a plea. But you have not.
Possible to do that. No, otherwise the booking will be.
Don't come up, Mr. Kaushik, you know this court.
I am,
This court is not such a easy court to get past through a motion unless you have a case.
I understand.
And you have made that out of it. Or that you get some stay out here after coming
No,
of the
it's
eight
not all.
months. Absolutely no. This type of cases is absolutely discouraged.
No, of course.
I
not.
think
I,
to impose a cost of 15,000. This could further impose the cost for
I'm sorry.
unnecessary litigation. This type of matters don't come. You have a case, you come. You no quarrel with that.
this, they,
But you don't have a case. You should have, what should we should have done? You should have filed immediately an order 7, rule 14(3) application seeking leave.
this,
You have come before this court with a false pretense. You have come after this court after 8 months. Why? Should have passed any further direction that why on earth the trial court have not proceeded with the suit? It has been fixed for cross-examination of the plaintiff witness. What has happened? It has not happened for the last 8 months. For what good reason?
all of the tender by application. But 7(9), that list of documents which was submitted, it was assumed that the originals are submitted, it is endorsed that admitted.
You cannot assume because the document which the petition which was disposed of does not mention contains various documents. And
That's-
these documents are not the documents which are exhibited as 6(1) to 6(1). The other list which you are mentioning is not a part of the petition which was disposed. And it could not have been a part of it, taking into account that your application which was filed in 2021 was filed in 2021. This cannot come up with this. Come up with this type of cases.
But I may be allowed to the liberty to file.
No liberty business. No liberty business. We have spoiled enough time. A lot of answers for you.
I'm sorry.
We should impose cost of 10,000 to be paid to the legal. Not the Guwahati High Court Advocates Association for spoiling the time is precious lawyers.
I'm sorry.
Mr. B. Kaushik, the learned counsel, appearing on behalf of the admits that he would like to withdraw the instant taking of the petition stands.
All right.
Yes, what is your case?
Plaintiff lordship, the petition of the plaintiff in the suit, lordship, we filed a suit for right titling interest and recovery of possession. Lordship, after the completion of the plaintiff evidence, lordship, the DW 1 and 2 were examined and cross-examined. Thereafter, DW 3, lordship, filed his evidence, lordship, along with some documents. The plaintiff objected to the same.
File certain
Yes.
documents, DW3.
Yes. And the plaintiff was the petitioner in the suit, lordship. He filed a petition saying that these documents cannot be exhibited as these documents have been filed at a belated stage and not been used by defendant number 1 and 2. So he paid for de-exhibiting the document. So the interim, there is an order, the interim order which I have challenged. That lordship will come to page 26, lordship. Get enough opportunity while I cross-examine that witness.
What is wrong with that order?
The difficulty is that the DW3, the evidence of the cross-examination has been dispensed.
4 times.
That is
4 times.
what I understand.
One
But-
time is 25,000, 4 times is 1 lakh.
The only thing is that one part of the order, the learned court below has said that I will get opportunity. And although
Yes,
I was-
absolutely, because the problem arises there. When the document has been exhibited and marked, you cannot de-exhibit. concept of de-exhibiting is foreign. And you, even after de-exhibiting, your lawyer out there said that I'm not going to cross-examine, even after DW4 has come 4 times.
That is the difficulty the plaintiff is facing now. The cross-examination of DW3 has been dispensed. That is the difficulty that the petitioner is facing.
Then what is the next date
Next date is 21/5
for
for
argument?
for document,
What documents? Can't be.
for producing a copy of High Court's order.
Where is that order? Show me that. Why haven't you enclosed? I don't understand. You are coming in between.
After filing
The last date
petition,
is
that
of
order is passed.
5/3. Why don't you say? Have you mentioned it in your petition?
After filing of this petition, Lordship, that order was passed.
You filed the petition when?
Twenty-eighth of April,
28/4. What happened on 5/3? Why haven't you mentioned in your petition?
29/4/25, Lordship, there is an order that the next date is fixed for certificate.
What happened on 5/3? 5/3/2025. What happened? Why haven't you mentioned in your petition? I don't understand. What is the problem with the lawyers? Here also in the earlier matter also the lawyer has not mentioned. Here also, you are filing this matter on 28/4/2025. Why haven't you mentioned what has happened on 5/3? On this ground, we should discuss. Okay,
That Lordship,
you have a case, but you have a, what do you call? First, you make a mistake. Person is very much there. He has appeared on 4 occasions, but this has happened.
5/3, there is an order fixed for further DW evidence, if any, argument.
For ejectment, you are the plaintiff.
I'm the plaintiff.
Who is DW3?
DW3 is one of the is the relative of DW is plaintiff, Lordship.
What is your ground for ejectment?
Ground for ejectment is that I have purchased 3 bigha of land out of 8 bigha of land, 8 bigha land from one is Gogoi, Lordship. Now, I have cultivated agricultural products over there and even constructed my house. Now, these defendants, Lordship, have entered into my land and they.
You amended your claim.
Lordship,
Have you amended your claim? You are seeking a suit recovery of khas position. We have earlier a degree for ownership. We have. You don't have possession of,
possession, we have over 3 bigha of land. Lordship.
but you don't have the possession of remaining the land.
Remaining 1 bigha, Lordship, that is the bone of contention in this matter. Now, in the written statement, they have stated that
Your suit will
defendants
be
are in
dis-
possession
your
of that.
suit will be
1 bigha.
dismissed on that ground.
Defendants are in position of 1
Why
bigha.
do you require all these things? The suit will be dismissed on that ground. It's a recent judgment to the Supreme Court has come on that. There is no point.
I mean,
Your suit will be dismissed.
cross-examine.
I can't give it to you like this. So you have not mentioned what has happened on file. When is the next date fixed?
21/5.
File an additional affidavit bringing what has happened in the meantime. You see that the instant petition was filed on 28/4/2025. But there is no mention in the petition what has happened in between on 5/3/2025, which was the date fixed for defendant evidence and arguments. So the learned counsel submits that he will file an additional affidavit in that regard, bringing on record the order so passed by the learned trial court. So list the matter on 9th of May.
Some difficulty.
Sure, no, we have it on 23rd of May. 23rd of May, as per the request. It's the sport had granted time to file the affidavit on This court wanted to list the matter on 9th of May 2025. However, the council appearing on behalf of fixed for another date. Accordingly, list the matter on 23rd of May.
Limited item 55.
April.
What are you challenging?
Challenging lordship, I had filed an application before the appellate for calling the record of the case number 39, which was lying in the court of the executing court, lordship, in the same company. That prayer has been rejected because lordship, when the appeal was admitted and fixed for hearing, lordship, then after checking the reports, I come to know that the LCR of Mr. case number 39 has not been sent by the executing court to the appellate. So I pointed out this matter was filing application. And but that my prayer was rejected. Because the first appellate court is the court of your lordship, the fact and law. All records must be before the appellate court, lordship, but that was rejected. That your lordship will find the improved order page 227.
You are the appellant.
And the appellant is stranger to this. I was not one of the defendants.
So you moved an application under order 21 rule 97.
97.
That was dismissed.
That was dismissed without recording any evidence.
I am not on that.
Yes, that was
dismissed.
then
So
I
against
filed.
that, you have filed an appeal. So you want the records of that case.
Only lordship, same campus.
Not the facts. That record of 2018, what's what happened? That application was filed in the year 2010. Order 21, Rule 97 application was filed in an execution case in the year 2010. That was disposed of on 23/12/2010. So therefore, they deferred an appeal.
Who?
The appellant. Challenging the order dated 23/12/2010. That was numbered as 19 of the 2011. So in the meantime, after immediately dismissal of their application, DP has been executed. So then they deferred an appeal. That appeal is pending since the year 2011. And so for these cases concerned, they filed an application for an execution case after deferring the appeal. That is of 2018.
And this is under order 21 rule 99.
That is not the application, mistake case 39, it is not related to the appeal. An appeal was deferred in the year 2011. So how this record is agreed your law? Because an appellate court cannot decide these questions. There is not subject matter of the appeal.
The improved order nothing to discuss what my Lord and Father has done. And that is not the correct.
Let us see the earlier order where the reports were for records. We want the record. Is the music case number 39 of 2018 before the learned first appellate court or not?
Not say it is an executing court.
Understood. This appeal which is being filed is against the order of music case number 39 of 2018? Huh? It has to be. or no?
No. This appeal relates to the order dated 23/12/2010, passed on the basis of an application order 21/97, which are dismissed, and against that appeal was made.
Now, is this case number 39 of the 2018 pending or disposed?
Pending before the learned trial, learned executive,
They have filed
lots,
under order 2199.
lots. No, this is not an order 21.
What is that?
That is an application, your lordship, what happened?
No, 39 was allowed.
That is an application, your lordship, under section 151.
What?
Or they want to submit that document before the learned executive court.
No, no, what is 39 oblique 18?
But this is lordship.
Page 200, page 2. 218, 208.
Then application lordship 218, annexure 24.
21? Now, is there, you have got the possession?
So far, his room is concerned, I am not. So far, there is other digital property, got the possession. So far, the appellant is concerned, he is in possession of a room. At the time of execution of the decree, he entered in the negotiation with the decree holder that he will remain in possession till the building being constructed. Building being constructed. That was an arrangement before the civil law. Before the civil law. That was the position. So that question is concerned. So the appeal become infructuous, which they are now filing an appeal before the learned appellate court, challenging the degree, challenging the executability of the degree, which was preferred in the year 2011. It become infructuous. So that cause of action, first cause of action has been errored because I entered the negotiation with him. I entered a negotiation with him that you remain in possession of this particular room. He is sending the building being constructed. When I will make a construction, he will get a room. That was an arrangement with him. But he did not, in spite of that, he did not vacate the premises. That is why when we are going to construct it, actually building, so he did not vacate it. So we filed an application for re-execution of the building. That question is pending before the learned executive court. So the appeal is concerned, where they want the records, the appeal relates to the order of the 2010 passed under order 21/97, which was dismissed.
Now, Mr. Roy, now, in this miscase, you want this miscase only?
Yes, Lord. Because it was
Which-
filed and all the compromise agreement between the decree holder and the documents are filed along with this petition, Lordship. So this was a very vital petition. Your Lordship will speak to Pedro. Lordship may come to page 2220. This is the agreement dated Lordship 6/6/2011, executed between the present petitioner, that is a stranger, and the decree holder, Lord, by which I was allowed to remain. Thereafter, what happened, my lord? Thereafter, again, the decree holder filed an application under Order 21, Rule 35 for the reissuance of the delivery of the position, Lordship. Whereas the present petitioner is a stranger to the suit, Lordship. And Lordship, this law is well settled, Lordship, in the Supreme Court decision in Mohta case, Lordship, that if a decree holder does not want to evict any other person from the suit line, Lordship, subsequently he cannot evict, Lordship. They can be evicted only after following the due process of law or filing a fresh suit. Lord, that judgment is
Lordship, may please to produce para 25 of this judgment. And in the present case, Lordship, the Nazi reported that if there was a compromise between decree holder and the stranger, so that part was not demolished.
But you don't want the stay of the execution proceeding.
No, no,
You are not asking for stay of any, is it state the in view of
no,
this
no, no,
mistake?
no, Lord.
That is pending lordship, so far their application is concerned, that is disposed of, and whether the
Whether 39 of 2018 has been disposed of.
Yes.
lordship disposed of, there is an order, that is 222, page 222.
Both the sides when you say of the hearing, both the sides in view of the pendency. What is this miscase 112?
Lordship 112, that is an application filed under section 151.
No, no, no. That is 151 is miscase number 39.
Lordship, I'm
So
coming to
that is our application under order 21 rule 19.
112.
Your petition, no.
Lordship,
Miscase is this one, no? Application under 151 is the miscase.
Sure.
Miscase number 39 is only the
Yes, 39 is miscase, Lordship. What was my prayer, Lordship?
112, your lordship.
Please, just
112,
call for the
Annex
record
22.
in this, from the same campus, Lordship.
page.
Page 194.
So this is going on.
This is pending. Because already there is an application, earlier application that was disposed of against them, and this acquired application.
So what is,
Same.
what is the problem in this miscase number 39 being called by him?
Lordship, the appellate court, the appellate court to decide the appeal on merit, on the records available, and the records before the trial court at the time of disposing of the appeal.
But isn't that the appeal a continuation of the suit?
Definitely.
So if that be so, so if any subsequent event happens, any subsequent event happens, can the appellate court take note of
That
this?
question can be decided by the landed executing court, because so far the appeal, earlier appeal is
No, no,
concerned.
this, anyway, there is no adjudication going on in 2039-18.
Lordship.
There's nothing, no adjudication going on.
Well,
So under such circumstances, what has been held is that this has been obeyed, kept in abeyance. When is the appeal fixed?
Fixed today. For hearing. Lordship, or instead of calling the record, I am ready, Lordship. I may be allowed to file a copy of the miscase number 39 before the landed appellate court. That will also serve my purpose. Because
That is
Lordship,
the-
law is this.
Or learned AR can ask for a scan copy.
Lordship,
In trial court, not the permission. It's not
Yes.
given. A scan copy is not given.
not given.
Like here we get the
No,
scan
no, that
copy.
is, that procedure is not followed.
It's not done.
Not done.
Lordship, law is this, if a appellate court, if the, all documents are not before the appellate court, Lordship, the appellate court will not look out into the miscase number 39, Lordship. And I, sumoto, cannot file because law is this, Lordship, the documents which were filed before the learned trial court are executed, that the appellate court will consider on the basis of lower court's record. So that is my defense, practically. I may be allowed to file.
So this appeal is pending since the year 2011 because of their negligence. And we filed an application before the honorable court, which is still pending revision application for direction to dispose of the appeal with a short plea. In spite of their having order of the honorable court, they are not proceeding with the hearing. They are not taking part in the
No, no,
hearing.
no,
One
that
after another, their application has
That is
been
not
filing.
the correct.
There is an appeal of since 2011.
I was
regarding
in,
execution. This is the position of law.
Lordship, I am ready to do the bill hearing on Tuesday itself. If your lordship allow me.
An appeal of 2016.
No, that is renumbered. Because the order of the 2010. 2010,
And
your lord.
practically, we have argued a lot on both my learned friend and myself on 18-2 lordship, 15-2, more than 1.5 hours. Then when I wanted to go,
SP Lloyd, the learned counsel, appearing on behalf of the prisoner. That I think the learned counsel. The supervisory jurisdiction of challenging the order dated 9/2025 passed in title appeal number 19 bracket A of 2016 by the Court of the Additional District Judge FTC number 3 Kamruk Metro and Guwahati, whereby the application filed by the petitioner herein with the appellant under order 13 rule 10 read with section 151 for calling for the records of Ms. case number 39 of 2018 from the learned trial court was rejected. The learned counsel appearing on behalf of the appellant, petitioner had put a notice of this court that before the appeal was initially filed in the year 2011 against the dismissal of the application under order 2197, 97 and 101. That is case number 43 of 2010, arising out of title execution case number 4 of 2017. But in the meantime, there has been certain subsequent events which have been brought on record by the Ms. case number 39 of 2018. And as such, as the appellate court is a continuation of as the appeal which is being heard is a continuation of a proceedings under order 21 rule 97 public 101, the instant the said application which contains the subsequent events ought to have been called for by the learned trial court, by the learned first appellate court, that is the court of the additional district judge, FTC number 3, Kamruk Metro at Guwahati. That's your submission. That's your submission, huh? It's the Article the learned counsel appearing on the submitted that the appeal being an appeal directed against the order dated 23/12/2010 passed in Ms. case number 43 of 2010 arising out of title execution case number 4 of 2017. The learned first appellate court was justified in rejecting the application for calling the Ms. case number 39 of 2018 as the said application has no relation whatsoever to the adjudication of the order dated 23/12/2010. So this court has given an anxious consideration to the respective submissions and is of the opinion that the opinion that as the appeal which is being pending before the learned first appellate court is a continuation of a proceedings under order 21 rule 97 and 101, which is case number 43 of 2010. This court is of the opinion that all subsequent events are therefore required to be subsequent events, if any, as the subsequent events which have been mentioned in Ms. case number 39 of 2018 may have some impact on the adjudication of the said appeal. Considering the above, Mr. SP Roy submitted that he would like to produce the certified copy of the application being Ms. case number 39 of 2018. And what about the documents? You have the original?
I am having.
And as the, like to produce the certified copy of the music case number 39 of the Pennsylvania and but they would not give a certified copy of the documents enclosed. You have enclosed two documents to that application. That is agreement you have. And the other is the sale deed.
Sale deed.
Sale deed you have.
What happened, Lordship, after eviction of, ejection of the defendant, original defendant of the, I am asking. The plaintiff Lordship responded, sold land to 4-5 persons by taking for the, it is a land situated just.
Do you have a certified copy of the sale deed?
Sale deed I have given, one, the land has shown that the respondent
Is
plaintiff has
this,
sold the
do you
land to
have,
one.
Mr. Roy, do you have a certified copy of this sale deed?
I am having zero.
Huh?
Zero. I have annex zero.
Submits that, Mr. SP Roy submits that he may be permitted to even give the certified copy of the music case number 39 of the 2018. And he will also produce the photocopy, produce the original agreement dated 6/6/2011, which is document number 1 to the said application, and a photocopy of the sale deed dated 17/6/2009, which is document number 2 to the said application. Pushpa. Taking into account the above, this court fixes this map. This court have also duly taken note of that today is the date fixed before the learned first appellate court for arguments. With the arguments of which that there is great urgency in this application, exposing of that need. And with the SP Roy submits that he can do the hearing on any agreement fixed. Accordingly, this court fixes the appeals for hearing before the learned first appellate court on 27th of May 2025. The
It's 9 law, because it will take some time now to certify. 27th May.
May. On 29th of May 2025, before the learned first appellate court. The petitioner hearing is the appellant in the CDP can file the certified copy of the application being the case number 59 of 2018, as well as the other documents before the first appellate court on or before 27th of May 2025. This court further it is a copy of the order. The present order be also produced before the learned first appellate court by either of the parties. And on the receipt of the instant order, the learned first appellate court may also in discretion also a scan copy of the Miss J case number 39 of the 2018 puस्तक. The learned trial first appellate court on the basis of the above shall make an endeavor to dispose of the appeal at the first.
I'd like to take 1 month of Lordship because we are suffering.
At the earliest,
At the earliest.
the earliest. And preferably within 1 month from the date.
To take any steps, but the recovery proceeding that is going.
which has been passed, that has been passed on the basis of an application before, on a, not an application, just, not, RG 125, your lordship will kindly, 125. The basis of this, that neither petition, nothing, they say that submit that the action taken by so and so bank has been withdrawn and hence great report is brought to matter as follows. Further to submit herein that all OTS proposal of judgment letters have been rejected by the certificate. Hence prayed for attachment of the property as involved in the matter. So only on the basis of this
No, but before that, they have filed a recovery application.
recovery application is going on. Once certificate is issued, my lord, that my lord, this recovery proceedings is initiated before the recovery procedure. So where, while it was going on, my lord, the tendency of the recovery proceedings, my lord, they have taken steps under surface, it was challenged. So there was a stay. So ultimately, they have withdrawn that surface activity. After this is been withdrawn. Now thereafter, they filed this application that was on 31/1/2019. This is not this simple paper. On the basis of this, my lord, the recovery officer passes an order of attachment. And
No,
no
no.
objection, nothing.
Uh, This application was filed before the recovery officer,
Recovery,
but already there is a recovery proceedings.
yes, recovery
So
proceeding.
it is in continuation to that, this
Yes.
application was filed.
Our contention is that, my lord, that once this is filed, that no, my lord, he says that, my lord, no affidavit, nothing, not even a petition. Now, at least an opportunity also have been given to us that, yes, they have filed an application, we filed your objection, nothing. We were not even heard. So on the basis of this, my lord, this order was.
You were present. On 31/1/2019, you were present.
They have filed it, my lord, we have also filed Hazira, my lord. That is ordered, we have not passed.
So you deposited a demand draft of rupees 2 lakhs. And you see page 126.
Yes, my lord, has deposited, they have also, because on each and every date, we have been depositing some amount.
So you have already deposited.
Yes.
Then what is wrong with this order?
Because before,
And now what has happened in the meantime?
now, my lord, we have been paying before the, on each and every date, we have been paying before the recovery officer depositing some amount. So ultimately, my lord, said that because whatever we are depositing, they are adjusting against the interest part. So therefore, my lord, we
So
are-
if you have any problem, you have to go under 226. Because as of now, nothing remains. There was no stay granted in this. Now, what is happening is that you are participating in the recovery proceedings, you are making certain payments, and the authorities are doing it. Now, if you have submitted an yes before the authorities concerned, and they have not taken into consideration anything, you have to therefore go under 226. How will this court look into this?
the pendency of this petition, my lord, as this OPS, proposal of OPS is coming. Because otherwise, we have been depositing. If the, my lord, the
Sir, have you made the submission before the recovery officer that we have submitted the OTS?
we have been submitting before the recovery officer, my lord, because as we have been paying some amount. So, my lord, the recovery officer is keep on fixing a date.
So you want that this matter should be only kept pending
No, no,
so that you have
let
some
it, my
bargaining
lord.
power. Otherwise, then there are no
No,
other
let,
case.
let it be referred to mediation, my lord, that,
Mediation,
because, my lord, if it had it been, my lord, this.
227 power for mediation is not.
Had it been a, my lord, case that the petitioner had borrowed money for,
That-
my lord, a housing loan of 10 lakhs,
I can't do that.
already 23 lakhs paid, my lord.
You have paid good. Whatever may be, the recovery officer has considered. If he does not consider, then you can come before the court.
I think, my lord,
You have to make a submission of that,
now,
whatever.
now
it is.
these, as we are agreeing.
But the question is, what do you want here? What do I give you now here? If I interfere with this order also have no sense. It is already attached. Once it has been already attached, now you are therefore, thereafter there being no stay, you are participating in the said proceedings. You are making payments to them.
On each and every date.
You are making payments to them. Whatever may be, you are making
So that
payments.
The
Hey,
when
come
we-
up with a solution there. This is not the court to give you any solution unless you say
because we have
that
this
keeping this
attachment
matter
order.
pending will help you in having a better deal. Tell me, you make that submission. My
Then let
thing
them
is
let-
not working properly today, so you can make that submission.
Let them, my lord, say whether it is.
I'm not going to say anything here.
The
The
respondent-
order
let the
appears to be
respondent say,
correct.
my lord, whether that is acceptable to them or not.
If they are acceptable, not acceptable, first of all, this court can't force them.
But that is why. But if it is not
OTS is a
acceptable,
one-time settlement which is between you and him.
Yes,
This is the
you
matter,
cannot direct
the law is very clear on that. I can't do anything on that. The Supreme Court is also made it clear. I can't do anything to that. Nothing remains
we are,
here.
we are agreeing by this order of attachment.
Order that you agree, but nothing remains. What remains now?
Order of attachment. This
So then let
page
them go ahead and
129.
do again attach.
Act wise 120.
It has been attached in 2019 and it is going on for the last 6 years.
129, my lord, that order of attachment. Here, my lord.
Understood? It is attached because this amount has not been paid.
The amount has not been.
You
paid.
want to
What is
remove this attachment, you have to pay. Matter is over.
amount, the pay means now what is the amount? They are saying, as per their calculation, they said that 23 lakhs, now they are.
Hey, the recovery proceedings is going on against what? If the recovery proceedings is going against some DRT judgment,
And therein, the rate of interest is at 10%.
there's a DRT judgment.
Yes.
Now, the recovery officer acts as a executive court. So whether it is satisfied or not, is for the executive recovery officer to look into it. What can I do up here? I can only observe to that effect that the recovery officer shall deal with it and look into it. Because, but if I make that observation, only thing is the recovery officer will act fast, which may not be in your interest.
Otherwise, my lord, that even, my lord, this order, in order of attachment, which is been passed, my lord, without affording any opportunity to us, and only on the basis of this.
Whether there was a prayer for attachment in the recovery application.
The, in the main application. Yes. Because the order, the order
You
of the.
don't need
yes,
it.
the
Why?
order
The
of the
question is whether you have made the payment or not.
lordship will kind to the order.
Attachment means what? You are still running it. You are using it.
Yes,
You can not only sell it.
yes.
That's it.
But we don't intend to sell it also.
No,
It's
you
97.
really-
For a moment, you paid 97 lordship.
Eh?
97 of the main fee.
Yes. To recovery certificate in favor of AF for a sum of rupees 21 lakhs.
20 lakhs.
With interest at a rate of 10% with quarterly rest in realization. This order is has again finally. Now the question is-
Amount paid by the defendant after filing of this application shall be reduced from the certified amount.
Okay, now this is the duty of the recovery officer to do.
Yes.
Let the recovery officer go ahead.
That is why, my lord, the recovery officer, before issuing this attachment order, now they find.
Understood, but it has been attached for the last 6 years. You go ahead. I think it's a. Or Mr. Eid asked the limit council appearing on behalf of the bench. And has appeared on behalf. You are appearing?
Respondent number 3 on behalf of M.
So, my lord, we was to form this court, my lord, whether proposal is acceptable to.
Not
Let him, my lord, form.
for me. Appears on behalf of the respondent. The present application under Article 227 of the Constitution is challenging the order dated 31/1/2019. Passed by the recovery officer of the Debt Recovery Tribunal Guwahati in OA number 212 of 2012, whereby the property in question, the immovable property in question was attached to the petitioner herein who is the, what is the other one? Recovery certificate? You are what? Certificate debtor. Huh?
Certificate debtor.
You are the certificate debtor. With the certificate debtor in OA number 212/2012. Submitted that the case of the petitioner hearing who is the certificate debtor in OA number 212/2012, not 2012, is that the state order of attachment was passed by the recovery officer without giving a due opportunity to the petitioner to oppose the application seeking attachment. The learned Mr. A. Das, the learned counsel appearing on behalf of the petitioner, has submitted that the said order was passed merely on the basis of a application filed by the advocate and not even the certificate holder, which is not permissible in law. The learned counsel further submits that in the meantime, even after filing of the instant application, as there is no stay to the recovery proceedings, the petitioner have been appearing before the certificate holder, before the recovery officer, and have also been making payments towards the satisfaction of the order dated 14th of December 2017, passed in OA civil OA number 212/2012. He, however, submits that while the proceedings are going on, the while the said proceedings are going on, the petitioner had submitted various proposals for a one-time settlement as per the norms of the Reserve Bank of India. But the assigned certificate debtor, certificate holder, but the substituted certificate, substituted applicant, that is the Asset Reconstruction Company India Limited, have not given any importance. Have not given any importance to
When this order under para 23, we have specifically
importance to such an application, to such proposals. And the petitioner herein is actually and the petitioner herein is not aware, even after making various payments as to how much the petitioner actually is required to pay in terms with the order dated 15/12/2017. Which order you are referring to?
under this, while this order was passed, my lord, we were not even heard. The order was
That I've already mentioned.
yes, and we have specifically stated in para 23.
I mean, I've already mentioned it out there that this was done without even a and on the men. I've already
Orders are passed.
mentioned it. This court have also taken note of the various orders being passed by this court from time to time. Wherein the respondent number 3, who is the substituted applicant public, the substituted certificate holder, was asked to provide proper computation of the statement of accounts. Has he provided anything? No.
So initially, before this code, he had provided at 12%, then your lordship said that it has to be at 10%. Yes, I think PDP my lord, saying that
On to it is further seen that in the order dated 6/12/2022, this court had duly recorded the statement of the counsel appearing on behalf of the respondent number 3, that the entitlement of the respondent number 3 was rupees 8,27,838.72 as on 14/7/2022 after adjustment of all payments made by the petitioner. So, then he filed an affidavit.
they have filed an affidavit, my lord, so it was filed on 6.
The record further reveals that did he actually file that affidavit? That an affidavit was filed on 27/7/2022, wherein a statement of account dated 27/2022 was placed. Giving details as to how much the respondent number 3 is further entitled to.
I affidavit, my lord, that was a wrong calculation. Subsequently, we had filed 6/8/20. Was a correct calculation. On 6/8/22, my lord, the affidavit it was filed. That was the correct calculation. So it is
No, he has filed on 6/7 and on 27/12, 27/7. You must have got it on July, August.
27/7 is the wrong calculation. Because 27/7, I think he has calculated at the rate of 12. Then 12%. Then your lordship pointed out that it has to be at the rate of 10%. So
No. That is in respect to this, which he filed on 6/7.
on 6/8, he had filed the at the rate
No,
of
6/8.
6/22. You have served the copy on 6/8. In that, he had calculated at the rate of 10%.
There, how much he has given? No, there are another affidavit. I have it. See, one affidavit is filed on 6/7. This is 6/7. 6/7. Yeah, this is 6/7. This is 6/8 or 6/7?
6/8.
Stamp to my. on 6th. Subsequently, there is another affidavit being filed, petitioner affidavit filed by the respondent number 3. Wherein how much is due now?
They are 23 lakhs something.
Is further due.
As per that calculation. But
Another further due.
the total due is 10 lakhs, 23 lakhs something, as per their calculation. Because they have initially this, at the rate of 10%, they have calculated, and they have found it at 23 lakhs. At 6 said.
Dated as on 2nd of August
August, yes.
2022,
23 lakhs.
an amount of rupees 23 lakhs 33,289 is further due.
We have also made a calculated by a chartered accountant as per this calculation. It comes to around 13 lakhs.
It is also said that pursuant thereto, an affidavit was filed by the petitioner on 25th of November 2022. How much is due?
As per them, it comes to 23 lakhs. What amount, my lord?
No, as by you,
As per our 13 lakhs, 13 lakhs 88,136 as on.
where is that? Not this one. You have filed one affidavit on 25th of November.
This is. As per this, my lord,
Wherein it was mentioned that the total amount payable to the
827.
respondent number 3 is rupees 8,27,838.72 as on 14/7/2022. This court has given an anxious consideration to the above matter. And as presently the duty of the recovery officer is to recover so much of the due which have been permitted by the presiding officer of the Debt Recovery Tribunal. In the adjudication of, while adjudicating OA number 212 of 2012 by the judgment dated 14/12/2017. This court have also taken note of the judgment dated 14/12/2017. And from the same judgment, it is clear, the directions are very much clear. Considering the above, as the said recovery proceedings are presently ongoing, this court would not like to further interfere in the present proceedings under Article 227 of the Constitution. However, could observe that the recovery officer shall proceed with the recovery in terms with the order judgment dated 14/12/2017 after taking into account the amount which have been duly paid by the certificate debtor, that is the petitioner hearing. The recovery officer shall further take note of which liberty is given to the petitioner to submit necessary certificate and necessary computation showing as to what amount the petitioner hearing is actually liable to pay to the certificate debtor. Liberty, how, Mr. Adas, however, some further, before parting with the record, this court, however, observes, further finds it relevant to observe. Take note of the take note of the submission of Mr. Adas to the effect that various proposals have been given to the certificate debtor for a one-time settlement. But the same have not been taken in spite of various circulars of the Reserve Bank. The closing of the instant petition. However, this court, in this regard, would like to observe that the closing of the instant petition and the direction passed herein above shall not preclude the petitioner to approach the appropriate forum if so agreed by the inaction on the part of the respondents hearing to adhere to the Reserve Bank circulars.
At order dated 12/4/19, this order was stayed.
By this court,
This 12/4.
attachment was stayed.
Yes, attachment was, if it proves my lord, then the attachment will again revive. They will again put it to auction. So this attachment goes. Now they will, my lord, this, the dates before the tribunal, my lord, someone will go and file an application.
That is what I asked you now. Where is the stay?
12/4/19. Attachment was stayed, but recovery was not stayed. Because we have been paying.
कौन लिखी हुई है? कुछ पता नहीं कब पैराग्राफ होती है। It has filed a petition on legal person. It is seen that by an order dated 12/4/2019, this court had stayed the order of attachment dated 31/1/2019 until further orders subject to deposit of ₹2,50,000 before the learned recovery officer DRT. The petitioner thereupon have duly deposited. Thus, I was asking you this very aspect only. Why have you not answered this?
Lordship was asking whether there was stay of the proceeding. Proceeding was not stayed, but this
Because
was-
you see, once you stay the recovery, the attachment, the
Yes.
proceedings has to be stayed, otherwise how can there be a recovery?
there was no such direction that the proceeding is stayed. But
This is the question you are. This court have duly taken note of. Duly taken note of. that by the order dated 12/4/2019, the impugned order dated 31/1/2019 was stayed subject to deposit of an amount of rupees 2,50,000. It is seen that pursuant to the said order, an amount of rupees 2,50,000 was duly deposited before the learned recovery officer. This court, taking into account that the order of attachment, the challenge to the order of attachment is only on the ground of that there is a violation of the principles of natural justice, as the petitioner was not heard prior to passing of the said order, as well as on the ground that the proper application was also not filed. This court interferes with the order of attachment dated 31/1/2019. However, the interference with the order dated 31/1/2019 shall not preclude the recovery officer (DRT) to pass appropriate orders for attachment if the judgment dated 14/12/2017 passed in OA number so and so remains unsatisfied, and after giving due notice to the petition, remaining all these things might go most valuable. It only interfered with, but you can ask the court to pass another order. And I'll remove all these things, unnecessary things which I've said. OTS and OTS, liberty supervision, no liberty supervision.
Calculation part,
OTS, OTS, all calculation, all goes.
calculation part.
No, nothing remains. I'll only interfere with this order of 31/12, giving liberty to the courier to go ahead to for fresh attachment after giving you notice.
Thank you. I think the pin bottom, I got work of lately which has been closed, my lord, by lecture 9, my lord, page 66. Two orders. 866 last. So that also one last time. That is at page 60. Suffering from heart failure, my lord, had a heart attack from 28.
Where is the medical certificate?
Medical, I have certificate. I have. The heart attack, my lord, it's two, my lord. Start certificate, my lord. And over the typical papers to council, my lord. Is that my lord, this cross examination pending since
Where is the
long?
medical document?
Space 62, my lord, which are
What? What is the medical date? This is of 2024.
Yes, my lord, just
What about 2023?
24, one, my lord.
I'm saying about 2016-12-2022.
My lord, you are suffering from heart.
Where is that medical document for?
Since my lord, his support is heart attack on 28-1, my lord. Prior to that, my lord, he has been suffering from heart ailment, my lord.
And the heart attack on 28-1.
One
Help
minute.
it. You have not also submitted the medical certificate.
My lord, my lord.
It was further
my lord,
submitted in the
not-
petition that the medical will be submitted, but the petition of her did not turn up for hearing on the petition and the plaintiff had submitted no such document. Then
Because of his ailment, my lord, neither the plaintiff nor his wife, my lord, is also the plaintiff, one of the plaintiff. My lord, not to the court to submit his.
what happened on 16-12?
My lord, as per my instruction, my lord, we have said that he was suffering from heart ailment.
Where is your medical
Madam,
certificate for that?
Just suffering from heart ailment and ultimately. my lord,
Produce your medical certificate as on 16-12. Otherwise, you don't have a case.
skin well, my
And he
lord,
was very much discharged. Why did you file this application? When did you file this application? This application is also not on affidavit. Then 63 wrongly. Right,
when he
pass.
he had something, my lord, I have to.
Okay. I'll help it.
Google date, my lord. My lord, otherwise, my lord,
Sorry, this is a suit which has been pending for 2 years. 3 years at the stage of evidence of
my lord,
cross.
my lord, because my lord, it was earlier, my lord, due to COVID restriction, then my lord, it was matter of sending to local government, my lord. For a long time, my lord, it was pending there, my lord. The change from single date, my lord, old man, my lord, suffered.
When there is no COVID from 2022 onwards.
No, my lord, after that, my lord, I've concluded all the order sheets, my lord. This matter was then sent to local government, my lord, from 6 to 2020,
18-12-2021 for cross of PWs.
my lord.
18-12, 24 to 2022. Dependent present, 6-1, PW's official witness, nothing. Then for year for cross, nothing. Game for cross, nothing. M for cross, nothing. 11-8-2022, cross, nothing. Learned for defending a case for another date for procedure. PW's cross. Not how the trial court function. You have not given any medical document. Can't help it.
Prayers of both the sides, my lord, both matter were earlier fixed for.
You produce any medical document prior to that, then
My lord,
maybe I
I
can.
can. Try, my lord. Well, my lord.
I'm vacating the stay.
That, my lord, because stay was only granted last date, my lord, when, my lord, court was not inclined to grant time, my lord. Placed before this honorable court and the court granted stay on the, only on the last occasion, my lord, not at the date of motion, my lord. You know, at least, my lord, till next date, my lord. Stay, my lord. Speak, my lord, sorry.
This is not a case. Not a case where one can consider this. In fact, there was no interim order also after 22-7. 22-7 there is no interim order. Then the last occasion.
On the
there
last
was
occasion, my lord, when I created my lord.
notice.
Okay,
Sorry, one has to be strict.
my lord,
Whatever
next
case,
week, my
you
lord,
don't want to file a case. When you file a case, you have to be more careful. These medical documents which have been produced here. Mr. Pitsundi, the learned counsel appearing on behalf of the petition. None has appeared on behalf of the respondents on court. A instant petition has been filed challenging an order dated 9/5/2024, passed in title suit 15K, 2014, pending before the court of the Civil Judge, Junior Division, Pulia, Nagaon, whereby the learned court had rejected the application filed by the petitioner, taking the calling of the order dated 16/12/2023, passed by the learned trial court. This court have duly perused the reports, and it is seen that the suit had been fixed for evidence of the PW's for PW's cross since
Since 6/2/2020.
Huh?
6/2/2020.
6/2/2020. 6/2/2020. 6/2/2020. System. It is also seen that every time when the matter has been taken up, the cross-examination of the plaintiff witness have not taken place. Further to that, the records, this court have also perused the order dated 16/12/2023, wherein also again another adjournment was sought for after after been sought for, which was rejected by the learned trial court on the ground that there was no medical evidence, there is no documents showing that there was no medical documents produced in support of the ground taken. When this court inquired with the learned counsel appearing on behalf of the petitioner as to what, as regards the ground for medical examining, as regards to any medical document, learned counsel has drawn the attention of this court to Annexus 7 of the instant application. A perusal of the said Annexus 7 only mentions about date of admission on 28/1/2024 and date of discharge on 2/2/2024, which is much after the order dated 16/12/2023. This court further takes note of that the petition which was filed before the learned trial court thereupon on 21st of February 2024 is also not supported by an affidavit. Such petition under such application cannot, in the opinion of this court, be taken up for judicial determination, taking into account the provisions of Order 6, Rule 15, bracket 4 of the Code of Civil Procedure 1908, as well as Rule 15 of the Civil Rules and Orders, Civil Code Rules and Orders framed by the Guwahati High Court. Considering the above, this court does not find there any illegality in the order dated 9/5/2024, for which the instant petition stands dismissed from the interim order passed on 4/4/2025, whereby the further proceedings of title suit number 15 of the K/2014 was stayed is hereby vacated. Very challenging.
File a case for the family court, seeking guardianship of this, adolescent. Your Lordship, the petition came before the learned court, Your Lordship, family court on 19/12/23. Your Lordship,
Which order?
Your Lordship, Annexure 1, Your Lordship. Annexure 2, Your Lordship, page 32, Your Lordship. Your Lordship, since then, Your Lordship, the matter has been pending, Your Lordship. I have been deprived of even the visitation right, Your Lordship. I have filed four
Application filed by
applications, Your
Iman
Lordship.
for custody of the minor child. The case was transferred to the Chief of Iman, Principal Judge Family Court. It was filed when? 2023.
23. Thereafter,
Then-
Your Lordship, order was passed, Your Lordship, to the respondent was asked to file defense statement, Your Lordship. Since
Where?
Your Lordship,
No, what are you challenging here?
Your Lordship, actually, Your Lordship, what I am challenging here is, Your Lordship, my interim prayer has not yet been considered, Your Lordship.
What is your interim prayer?
Your Lordship, but visitation rights, I have not seen my son for 1.5 years, Your Lordship.
What has happened? The other side is not appearing.
She is able to remain absent, Your Lordship. Her conduct can be seen, Your Lordship, on the order 6, Your Lordship. And Your Lordship, even though last chance was given to file written statement, Your Lordship, by order dated
You are the father.
yes, Your Lord. Your
Then
Lord,
have they filed a written objection
no, Your Lordship, till now they have not filed a written,
in that case?
Your Lordship. Now, and Your Lordship, I have filed several other applications in between, Your Lordship. Okay. One application. This, Your Lordship, I wanted to spend the birthday with my son, Your Lordship. I wanted to spend the birthday of my son with him, so I filed an application, Your Lordship. But then the matter was in the court of, in the councillor's office, Your Lordship. The councillor, seeing the urgency of the matter, passed the file to the court of the principal just family court, Your Lordship. And a copy of that petition was handed over to the council of the respondent, though the respondent was not present. But on that very day, Your Lordship, when the petition was supposed to be heard, Your Lordship, the respondent remained absent, our counsel also remained absent. So these things are being going on, Your Lordship. Now, I have got a certified copy, Your Lordship, which I couldn't annex, Your Lordship.
There is no stay out here, na? When is the next day?
Your Lordship, the next date is on 23/5/25.
Huh?
23/5.
Or Mr. Mohammed I. Hussain, the learned counsel appearing on behalf of the petitioner. The instant petition has been filed seeking appropriate directions, taking into account that the petitioner's application filed under Section 7, read with Section 25 of the Guardianship and Wards Act 1890, have not been taken up is pending disposal before the court of the Principal Judge Family Court, Kamrup Metro at Guwahati. And there is no progress within the said proceedings. The learned counsel further submits that even his interim prayer for having, for visiting, for meeting the child have not been taken into consideration, have not been considered by the learned court of the Principal Judge Family Learned Court. And it is under such circumstances the petitioner has approached this court. Footnote. Taking into account that the matter is presently pending before the court of the Principal Judge Family Court, Kamrup Metro at Guwahati, for the learned court of this court would not like to, not for the present, like to pass any directions on the application seeking the application the application as to how the learned court of the principal judge family court should pass the orders in the application filed seeking guardianship by the petitioner. However, this court observes that the petitioner being the father of the child has rights, has due rights to meet the child as it is always, as it is for the welfare, as it is always, as meet the child, in as much as the father's care is also an important aspect, important factor in the welfare of the child. Considering the above, this court inquired with the learned counsel appearing on behalf of the petitioner as to when the next date is fixed before the learned court. Below, he submitted the next date is fixed on 23/5/2025. Taking into account the above, this court fixes this matter again on 4th of June 2025. In the meantime, this court would request the learned court of the principal judge family court, Kamrup Metro at Guwahati, to expedite the hearing in respect to the interim prayer of the petitioner on the next date so fixed. So that the petitioner also is able to meet his child, who is presently around 4 years old. 4 years. 3.5 years. 3.5 years old. It is the learned court shall also bear in mind that the father's care is also an essential factor while deciding the welfare of the child. To produce that, okay? You don't require, this order will be enough for 23/5. I'm keeping the matter pending, that is why. I would have otherwise disposed of. If I would have disposed of, then you never know what is going to happen. So when I'm fixing it on 4th,
Age of the child.
you filed it in 2023. It was 1 year, 4 months. So we are in 2025. Anyway, it's 3 years for you. Around 3 years.
Then I before another observation. If you are responding to fail to file the written statement, then of 5 years old.
It's okay.
I have already filed my evidence.
Okay. Let us first look into this. You're meeting your child is here. Then we'll see later on. I've kept the matter pending, that is why. But liberty given to the petitioner to mention the matter of arbitration in the next. This will put.
Right.
Yes, what is this?
The interest is not awarded 12%, the conditional interest is given. Income note, this is heavy truck driver note, which is secondly 8,000 note. And my income price certificate is there, is 15,000 note.
Where is your substantial question of law?
There are 9 notes.
These are not substantial question of law.
There are 9 page 9.
Was perverse in respect of conditional interest award and not awarding interest from the date of the accident, and whether the claimant is entitled to for interest from the date of the accident instead of the date of the judgment. Where is the judgment? Claim petition is allowed along with so and so only awarded as funeral expenses only to the claimant and so is hereby the deposit. Understand? Within a given- On the date of the accident,
If not paid,
yes,
but there is no interest if the amount is deposited within 30 days.
have they deposited?
No, I don't know actually.
No, I am asking you, have they deposited? The award, order was passed on 5th of February 2021. I'm asking you a specific question. Have they deposited?
They have deposited.
When?
That I don't know.
Find out. If they had deposited after 30 days, then you are entitled, then this question of law does not arise.
The date of accident, the interest is paid.
From the date of the accident,
Yes.
you are given more.
No, they have not.
Are you appearing for the insurance company?
No, no,
You are appearing for the claimant.
claimant.
So if that is given, it should have been from the date of filing of the claim petition
Yes, no.
and not from the date of the accident.
On the date of accident should be given. No.
Huh?
Interest from the date of accident in a WC acknowledgement, that should be given for the date of accident.
So it has been given.
But it is if no date. Conditional interest. Note, if
What is
no date,
conditional interest?
period of 30 days, if there is no interest. If they paid deposit will be 30 days. From the date
So
of judgment.
therefore, this award was passed on 5th of February 2021. So have they deposited within 30 days? That is my question. No, when was it deposited?
I don't know that.
Then no. Mr. A.R. Agarwal shall obtain instruction as to whether the amount has been deposited by the insurance company. Is the matter again on when? How much time?
Thanks.
The 3 weeks at the request of the. Item 10. What is this?
Order is 26. There must be one headline. The sun
Which order you are challenging?
is 26.
Page?
26.
Page 26 cannot be the order you are challenging. What is this matter? Why is it an FAO?
It's an order of review doctrine.
Huh?
Order of review doctrine. Worship. Order of review doctrine. Can we see lordship prior to that order, lordship, one order has been passed, page 20 lordship.
Mr. Counsel, what do you need to file is not an FAO. How can you file an FAO against the review order?
For my.
What order is
No,
this?
no, it is under, order 43 rule 1W.
Eh?
It will under order 43 rule 1W.
W.
Yes.
Understood. That I'm understanding it. I'm not on there. My question is, this is an MAC case.
Yes.
How are you filing that review? This appeal?
No, Lordship, not briefing. I am against the order of briefing, Lordship. When the dismissal
Understood,
order-
understood, but this is an order passed by a tribunal.
Yes.
How do you apply this order 43 rule 1W? I'm asking you that specific question.
I will, I find out the position. This is what is right.
Your appeal lies under what? Some Motor Vehicle Act. When it come to, his appeal is under 173. See, Motor Vehicle Act provides an appeal. This is under 173. 173 award it is only against an award. How are you coming against, somebody filed an application under order 110?
Yes.
Once that application was allowed or rejected, whatever may be, against that a review was filed.
Yes.
That review was allowed.
Yes.
So
Against
against
that-
that comes. If it is, but the question is, how do you bring in 173? The power of this court to exercise is only under 173, an appellate power. You see, order 43, rule 1R, 1W or 1R, whatever may be, springs from 104. Okay, now that is by the civil court. How motor vehicles tribunal will come in? Do you file an appeal under, when you file an appeal against an order of MSC, you file under 173. You don't file under order 41 or 100 or 96 because of the fact that the appeal lies under 173. Now, there is no appeal provided under this act to approach this high court. So what you require is to come under 227. Get the point? What are you going to do?
File a case.
Yes. Otherwise, you are losing your time. The learned counsel appearing on behalf of the appellant submits that he may be permitted to withdraw this application and taking into account the order so passed is by the Motor Accidents Claims Tribunal to be by a Motor Accidents Claims Tribunal. In as much as the appellant herein would be well advised to file an application under Article 227 of the Constitution challenging the order dated 10/2/2025. So taking into account the above, the instant appeal stands closed on withdrawal. So liberty given to the petitioner, the appellants to move this court, if so advised under Article 227 of the Constitution.
Limitation may be.
227, there is no limitation. Where
In the order, it is 77.
File an application under 152, my lord, for correction of clerical error of 3, my lord. Pata number, my lord, instead of 39. And as per plan, it has not given, it's given only 3.
we allow it to be
Your Lordship. In my humble submission, I want to submit that the section 152 petition they have filed in trial court judgment. That decree, that suit has been dismissed. They ought to have filed the section 152 petition in the appellate court judgment. The suit has been dismissed after it has been remanded back by this honorable.
So the appellate courts have prepared the decree.
Decree originally prepared by the trial court, my lord, thereafter.
But your suit was dismissed.
It was originally dismissed, thereafter, my lord, there is appeal, thereafter case was remanded and subsequently, my lord, the suit is decreed.
By
Again,
whom? By who decreed the suit?
Decree, trial court decreed, my lord.
Where is the decree of the trial?
A trial court decrees, my lord, at page. I copy, my lord, as at page 28, my lord, trial court decree. That
Where is the trial court judgment?
trial court judgment is, my lord, not given here, my lord, only decree is given, my lord.
Huh?
Decree is given here, my lord. In,
Court of the civil judge, no longer is the trial court.
yes, my lord. That, my lord, the page 33, my lord, that originally is that, my lord. Tabir Majid Tafsil ko Sapai Muzar Dulahal Gaur number may be better. But original plaint, my lord, it was specifically written in page 18, my lord, it was 39. And thereafter, my lord, the all decree, my lord, that tag number, pattern number was not mentioned in appellate court.
No. How this decree was prepared? Means there has to be a judgment.
Yes, my lord.
This is a decree of 1982.
Yes, my lord. Once it was remanded, thereafter, my lord, again, my lord, it was the plaintiff suit is decreed, thereafter appeal, thereafter second appeal, and after second appeal remand, after second appeal, my lord, dismiss, then my lord, file execution case. That's why, my lord, time.
No, why does the trial court hold it? That when was the suit? Why does the first this court holds it? Here you see in the present case, the decree of the trial court dated was set aside by the appellate decree, dated remand, and subsequently reversed by the decree of the civil judge Dorong on to mine. The appellate decree was. See, there is again another decree on 2006.
Yes,
Then why have you not enclosed that decree? Where is that decree?
Decrease there, my lord. 2006 decrease there, my lord. Two thousand degree is मतलब base 37.
Huh?
Base 37 degree 2006.
Huh.
Base 37 मतलब. Base 37. In that degree मतलब.
This is title appeal.
Yes, my lord. In that degree, the tag number, part number is not mentioned, only my lord, that's why the problem, my lord. The original degree that was mentioned. And thereafter, High Court decree, my lord, that is also, my lord, that tag number, part number is not mentioned.
Where?
High Court decree has at base 43, my lord.
Then why are you seeking execution of the 2008 document? The 2000,
Original
In
decree, my lord.
1982.
Original degree which is done in paper.
so why are you asking that?
My lord, because that only here, my lord, it was mentioned that the decree of my lord. That the part number was
Understood, but
mentioned.
why you are asking for execution of the 82 decree, which has no relevance?
This is the original decree, my lord.
Original decree is there, but that has been set aside by the first appellate court. And then it was remanded back.
Yes, my lord.
And then there was another decree
Yes,
by
my lord.
which it got dismissed.
My lord.
Thereupon you filed an appeal. The appeal was allowed.
Yes,
And the second appeal was filed by them, which was dismissed. Isn't it? So why you are on 82? 82 does not survive.
it has not mentioned, my lord, that earlier. That will man, I'll go to the earlier record, my lord, that next week. That-
You have filed an execution petition.
My lord.
Are you not filing an execution petition?
Execution petition, sir. I have filed
So-
execution petition.
Can't we apply this Pratibha Singh and more particularly in paragraph number 15?
Yes, my lord. And, my lord, that is-
Paragraph number 15, wherein it's not 15. Paragraph 15, 17. Here. Where the suit as to an immovable property has been decreed and the property is not identified properly, the defect in the court record caused by the overlooking of the provisions contained in Order 7 Rule 33 and Order 20 Rule 3, PPC is capable of being cleared. After all, a successful plaintiff should not be deprived of the fruits of a decree. Resort can be had to section 152 or section 47.
Yes, my lord.
So therefore, by virtue of section 47, they may not do under 152. But the court can very well, under 47, depending on the facts of the case, which the two provisions will be more appropriate, just and convenient to invoke. Inadvertent error not affecting the marriage, it may be corrected under year by the court which passed the decree by supplying the omission. Alternatively, the exact description of the decreed property may be ascertained by the executing court as a question relating to a decree of competent court should not, as far as that may be allowed to be defeated on this ground. So,
One case, my lord, change, my lord, even if appellate stage, my lord, that honorable High Court can clarify, my lord, that if any clerical. There are 14 and 15. If even High Court can do it, my lord. 14 and 15 and.
Mr. Goswami, each judgment is different. See, what mistake has happened is by the first appellate. The first appellate court, while passing the decree, he should not have only said that the appeal is allowed and granting the relief treatment. Yes. What he has should have said, in terms of order 41, you will 31, he should have mentioned. Now, in this case, it was the High Court who was the appellate court. And as such, it was directed with what the High Court did. High Court directed the trial court to make the decree, which could not have. The decree ought to have been prepared by the court itself, the High Court itself, in this case. Now, in this case, the appellate court could have done. So this can also be done. I can give you the liberty to move under 152. Because it is a judgment delivered on the decree has been approved only in 2024. You have time. So therefore, you can very well seek for appropriate orders on the 152.
And that.
You move that application. Heard Mr. C. Goswami, the learned counsel appearing on behalf of the petitioner. Who's the Miss so-and-so appears on behalf of the respondent numbers 1, 2, 3, 4, and 5, and 6 for the respondents. The petitioner herein has approached this court by challenging the order dated 18/12/2024, passed in Midze case number 70/2023, arising out of where in the suit you filed, na?
Yes, sir.
Yeah. Midze case number 70/2023 by the Court of the Learned Civil Judge Junior Division number 1 Dorong Mongoldo, hereinafter referred to as the Learned Trial Court. It is seen that by the order dated 18/12/2024, the application so filed by the petitioner under section 152 of the Code of Civil Procedure 1908 for short the code was rejected on the ground that the Learned Trial Court could not have prepared the decree, made correction to the decree, inasmuch as the decree was passed by the first appellate court, which is the court of the civil judge. What is the name? Civil
Yes,
judge?
Dorong Mongoldo.
Huh?
Yes, Dorong.
Like a civil judge. Civil judge Mongoldo. Presently, the court of the civil judge, senior division, Mongoldo.
Junior,
Junior
Division number 1, Dorong Mongoldo.
Understood. Civil judge Mongoldo. Presently, the court of the civil judge, senior division, Mongoldo. This court have duly heard the This court have duly heard the learned counsels appearing on behalf of the petitioner as well as the learned counsel appearing on behalf of the respondent. Mr. C. Goswami, the learned counsel submitted that as the decree in question is being put to execution before the learned, you have filed an execution case, na?
Yes, madam.
Have been put to execution before the learned court of the where have you filed execution? You don't know.
Correct.
You have not filed execution.
Here, ma'am, I have filed execution. Execution case number, my lord. Here is there. Execution case number.
Please check case number 1722.
No, that is his application.
Title execution 8 of 94, my lord.
Have filed an execution case number. Case number.
Date of
They
90
filed an execution. Comma. The which was been registered as title execution case number
8/94.
8/1994. Comma. The learned trial court, learned executing court, that is the court of the civil judge, learned trial, that is the court of the civil judge. Junior division number 1 at Moldova would have rectified the same mistake in the decree of inserting the correct factor number in exercise of the powers under section 47 of the Code of Civil Procedure. Per contra, the learned counsel appearing on behalf of the respondent submits that the decree so there is no decree properly made. There is no decree in accordance with Order 41, Rule 31 of the Code. Taking into account that the suit of the plaintiff of the petitioners was dismissed. She therefore submitted that without a proper decree, without a decree being drawn up in accordance with law, the question of going ahead with an execution proceedings does not arise. In addition to that, the learned counsel further submitted that the learned trial court, that is the court of the learned civil judge, junior division, number 1, Moldova, had committed no error inasmuch as the state court could not have exercised the jurisdiction under 152 to correct a decree which is not yet been made in accordance with law. I've given my anxious consideration to the respective submissions for ascertaining, for the purpose of adjudication, this court finds it relevant to take note of that the petitioner, how many petitioners? The petitioner herein had filed a suit being title suit number 23/1977 against the respondents herein, taking a decree for right, title, and interest in respect to the Schedule 4, in respect to the land described in Schedule 4 and the house situated therein, described in Schedule 4, semicolon, for a decree for cast possession in favor of the plaintiff over the Schedule 4 land and the vacant possession in respect to the Schedule 4 house, thereby ousting the main defendants and their family members. Semicolon. Decree for cast possession in respect to the schedule 4 land, thereby demolishing the house in schedule Go schedule, as well as any other house of any other house constructed by the defendants, as well as and for permanent injunction. In the said suit, the plaintiff have duly mentioned the schedules, have duly described the schedules. Pertinent hearing to mention that the periodic patta mentioned in the plaint was periodic patta number 39. Post. The said suit was decreed by the learned trial court by the judgment and decree dated 23/1/1982. And was decreed by the court of the civil judge Moholdoi by the judgment and decree dated 23/1/1982. Pusto. An appeal thereagainst was filed whereby the judgment and decree passed by the learned court of the civil judge Moholdoi was set aside and the suit was again remanded back to the learned trial court. In the meantime, on account of the change in the pecuniary jurisdiction in view of the amendment to the Bengal Assam Agra Civil Courts Act 1887, the suit being title suit number 23/1977 was transferred to the court of the civil judge, Junior Division number 1, Moholdoi. The said suit thereupon was dismissed by the court of the civil judge, learned court of the civil judge, Junior Division number 1, Moholdoi, by the judgment and decree dated 24/12/2001. Being agreed, the petitioner herein as plaintiff, preferred an appeal before the learned court of the civil judge, Dorong Moholdoi. Presently, the civil judge, senior division at Dorong Moholdoi, which was registered and numbered as title appeal number 4/2002. It is very interesting to take note of that the learned trial court, learned first appellate court, that is the court of the civil judge, Dorong at Moholdoi, by the judgment and decree dated 6th of what? 6th of July 2006. 6th of July, na?
This 37. 6th of July.
6th of July 2006. Or 4th of July 2006. Decreed the suit in favor of the petitioner. While doing so, this court finds at this stage relevant to take note of Order 41, Rule 11, Rule 31, Order 41, Rule 31D, which stipulates that the judgment of the appellate court shall be in writing and shall state where the decree appealed from is reversed or varied, the relief to which the appellant is entitled to. However, the same was not done so. Rather, the appellate court, first appellate court, that is the court of the civil judge Dorong at Moldova, allowed the appeal with cost and further observed that the plaintiff's suit is decreed as paid for in the plain with costs. It is further relevant to take note of that against the said judgment and decree passed by the learned first appellate court, an appeal was prepared before the court, which was registered and numbered as RSA number 140/2007. An appeal was prepared before this court by the respondents hearing, which was registered and numbered as RSA number 140/2007. By the judgment and order decree dated 21st of April 2023. Dismissed the said second appeal, thereby confirming the judgment and decree passed by the learned trial court, first appellate court. However, it is taken note of that the petitioner herein have filed the suit, had filed the execution proceedings, being title execution case number, on the basis of a decree, on the basis of the decree dated 23/1/1982, which no longer existed. The decree the execution proceedings ought to have been therefore filed against the decree and in seeking execution of the decree passed by the learned first appellate court in title appeal number 4/2002. It is relevant to take note of that as the decree passed by the learned decree passed on 23/1/1982 is no longer in existence. The question of an incorrect periodic patta being mentioned in the decree has also no significance. And as such, the question of seeking amendment of the said decree, which no longer exists, does not arise. This court now finds it relevant to take note of the judgment of the Supreme Court in the case of Pratibha Singh versus Santi Devi Prasad, reported in 2003 2 SCC 330, and the observations so made at paragraph number 17 of the said judgment, whereby the Supreme Court categorically observed that when in a suit as regards immovable property is decreed, any corrections so made, any corrections so required can be any corrections required in view of overlooking the provisions of Order 7 Rule 3 or Order 20 Rule 3 of the CPC is capable of being cured on the ground that a successful plaintiff should not be deprived of the fruits of the decree. This court further finds it very pertinent to take note of that in terms with Section 47 of the Code of Civil Procedure, the executing court has the power to ascertain the exact description of the discrete property and has the power in terms with Section 47 has the power to decide to deal with questions relating to execution, discharge or satisfaction of the decree within the meaning of the decree. Taking into account that the learned first appellate court, that is the court of the civil judge, Dorong, now the civil judge senior division Dorong at Moholby, had passed the decree thereby allowing all the reliefs as claimed for in the suit. It is the opinion of this court that the learned executing court on the basis thereof can very well, a learned executing court on the basis thereof can very well ascertain, very well grant the reliefs, execute the decree in respect to all the reliefs have been claimed in the suit. Considering the above, this court observes that the filing of an application under Section 152. Now, considering the above, the instant proceeding stands disposed of with the following observations, and instant application stands disposed of with the following observations and directions. Number one, the filing of the application under Section 152 for correction of the decree dated, what is that? 23/1/1982 in title suit number 23 of 1977 was misconceived, and taking into account that when the said decree is not in existence, the question of seeking rectification or correction of the said decree does not arise. Number two, the petitioner herein can the learned court of the civil judge, junior division number 1, who is also the executing court, shall proceed with the execution of title execution case number 8/2000. What?
Yes.
Oblique 1994.
1994.
8/1994. By making due correction, by proceeding with this, by executing the decree in terms with the judgment and decree passed by the learned first appellate court dated 4/7/2010.
06. 4/7/2006.
4706. Hey, is it 4706?
Yes, ma'am. 4th July 2006, page 42.
4706. And the same can be very well exercised in terms with Section 47 of the code. With above, the instant proceedings can. So you got all the reliefs more than what you want.
Okay.
I kept hurt word also.
Well,
Mr. Bora, in that case, that amendment case, I have allowed one amendment at paragraph number 7, wherein you wanted to change the number of the deed.
Yes.
From 12496 to 12695 or something. That I have allowed that portion and asking you to file the amended claim by 13/5. Take the order, huh? If you don't file, then only that is allowed, others will not. Yes, what is this? Second appeal.
If you have a minute at. Selective 4. At page 42. Trial court judgment. What happened? The present respondent has 25 title suit before the Munchip number 1, civil judge, Union Division number 1, Northern, being title suit of 53 of 2009. And state title suit, the defendant appeared and contested the suit by filing. It is settled. And after concluding time, the suit was decreed and counterclaim dismissed. And against that judgment, the present appellant prefer an appeal before the civil judge.
You are saying that there is no prayer for recovery of possession?
Yes, the in plain and consider there is no amendment
Page 21.
regarding the recovery of possession. And
As a degree of recovery of possession if the defendant will dispossess the plaintiff from the suit land during the pendency of the suit.
and page 21.
Ah.
And then pair number 2. Pair number 2 and page 21. Pass a decree of recovery of possession if the defendant will dispose the plaintiff from the suit land during the pendency of the suit. But there is no any disposition. In fact, present appellant defendant has been possessed since long day. But my present case is only that the learned both the court below pass the judgment and decree without identification of the suit land. This is my case.
So tell me one thing, during the pendency of the suit where the plaintiffs were dispossessed,
No, there is no
Okay.
you file an amended claim.
Lord, this policy. It has been established during evidence.
Did you file an amended claim?
Not, no amendment was not filed.
And how did the court come to know that you were dispossessed?
After evidence, Lord.
So at the time when you were in the suit, when you filed the suit, during the pendency, you were not dispossessed.
During pendency of the not.
Then why did you pray for in that manner? That if you are dispossessed, that
Lord,
you are.
where was that? Where was that part of duty for recovery person if the dependents disposes the plaintiff from the suit land during pendency of the
So there is no relief for you.
recovery
You
of
have not brought in the aspect that you have been dispossessed. How can the court grant recovery of possession?
person. When the evidence, during evidence it is found,
How?
because they are claiming that they are the occupancy tenant.
Maybe, whatever may be, but if you were in possession, where is the question of discovery? Because unless you bring on record by somehow, that somehow means only by way of pleadings, that you have been dispossessed.
So,
How can the court infer that you have been dispossessed?
Because the court, during evidence, court and one found that yes, they are claiming that they are occupancy tenant and they are claiming that in the principle they are occupancy tenant without their having any document. But their assertion is that we are in possession. And court found that their right title has been declared and court found that they are not in possession. That is why but one title has been declared. So that is why
But without there being anything, how is it possible?
but if they are saying that in the principle they are occupancy tenant.
They may say anything from that. But you continue to say that you are in possession.
It is our
Unless
land,
by
we
way
are
of an amendment you say that you have been dispossessed. And unless you say by way of an amendment you cannot lead evidence also,
Lord, that is correct.
then under such circumstances, how the relief for recovery of possession can be granted?
What happened? When the title has been established,
Did you say in your written statement also that you have been dispossessed? So they filed a counter claim.
counter.
Did you file it in your written statement also that you have been dispossessed? Then also this court can take note of that. Otherwise, no.
You may be given so that I can go to the written statement of
You will get a good opportunity after 5 years. Once I start, admit that you-
Moreover, very interesting, the landed first appellate court decided only one issue, and it takes 72. That is the only decide. Nothing more.
Now, the defendant duly admitted that you are the owner. They only say that you cannot evict them.
Yes.
On the ground that
That
they are occupancy tenant. Very well. Now, therefore, the question of right title interest is not an issue. Which both the courts have decided in your favor. There's no issue. But the question was whether you are in possession. Now, the fact that you have not mentioned anywhere that you are in possession, you are not in possession. Who's against you?
It has been stated that we are in possession.
That is the biggest problem in your case. And it was not necessary for the judge to write so much unnecessary. That is the only point.
Yes.
Writing after, yes, he duly admits that you are the owner.
Yes.
Or your predecessor is the owner.
Yes.
He has not gone under 23. Have you gone?
No. No, everything under it.
He has not gone. Now, he is not an occupancy tenant, can be culled out somewhere. But the fact that he is not he is in possession or you have been removed from possession, how can you say? Have you mentioned in your evidence also that you are not in possession?
So that is why the evidence will look into.
Well, this is a case for admission. A long time, Mr. L.K. Bora should also be.
Even my last has taken time. Even for the time, actually, he was.
The 5 numbers of capital question law have been.
No, I am proving only one. He may frame me, he may say me anything. This is to cut short. But Mr. L.K. Bora, the learned counsel, appearing on behalf of the appellant. Appellant or appellants?
Lens.
One thing,
Yes.
appellant number 1 has already died recently. All the details, other details are on record. Appellant number 1 never died on
Mr.
18.
L.K. Bora, the learned counsel, appearing on behalf of the appellants. At the outset, he submits that the appellant number 1 expired
18/2/2025.
18/2/2025.
And appellant number 4 has also died.
Appellant number 1, take together, na? Appellant number 1 and appellant number 4 had expired on 18/2/2025 and
9/4/2024.
24.
Oh.
So you filed against the dead person.
No. Earlier.
It has not yet been admitted.
Yes.
Admitted that the appellant number 1 and the appellant number 4 had in the meantime expired after the filing of the instant appeal on appellant number 1,
Appellant 4 died on 9.
appellant number 1,
2024.
appellant number 1 on
1 died on 18/2/2025.
18/2/2025 and
And
9/4/24
9/4/2024.
respectively. He however submits that the appellant number 1 and 4, the estate of the appellant number 1 and 4 is duly represented by the appellant number 2 and 3, who are their sons. Which taking into account the above, the names of the appellant number 1 and 4 are struck off. Question. The counsel appearing on behalf of the appellant shall file a fresh memo of parties before the registry of this court and within 3 days, and the registry shall, on the basis thereof, shall make necessary correction in the post title and also update the same in the CIS. Question. This is an appeal filed under section 100 of the Code of Civil Procedure 1908, challenging the judgment and decree dated 2/6/2023, passed by the Court of the Learned Civil Judge Nolbury at Nolbury in title appeal number 14 of 2019. Question. The instant appeal is admitted on the following substantial question of law. Whether the learned courts below were justified in between in granting the relief for recovery of possession when there is no pleadings to the effect that the plaintiffs were dispossessed during the pendency of the suit. Mr. R.K. Bhuya appears on behalf of the respondent numbers 1 and 2. Who are others?
Right.
Huh? Who are the performer?
No, we are not appearing lawsuit.
Not appearing. They actually only three.
Are you a defendant?
I'm the dependent, 1, 2, 3. Oh, 4, up to 4.
You are a defendant.
Yes.
You have no business with the performer. 1 and 2. Here's one. Extra copies of the memo of appeal be served upon him. As regards the respondent number, performer respondent number 328, Mr. L.K. Bora submits that their presence is not necessary, taking into account that their interests do not affect the rights of the appellants. Accordingly, the names of the respondent numbers 28 are struck off. তার পিছত কি কোন দিব fresh memo of parties কোন আছে এই অর্ডারটো তার পিছত হ্যাঁ বুঝছো Mr. R.K. Bhuya appearing on behalf of the learned counsel, appearing on behalf of the appellant, respondent number 1 and 2 submits that the matter be taken up on an urgent basis, taking into account that the suit was filed by the appellants by the respondent number 1 and 2 in the year 2009. Taking into account the above, list this matter on 10th of June 2025. The registry shall ensure that the records of the learned court below is the registry shall requisition the records of the learned court below and ensure that the records are available before this court on the next date so fixed. Liberty given to both the parties to mention the matter for upgrading. Finish it.
And 14.
My senior Mr. S.P. Chaudhary.
Who?
So S.P. Chaudhary, about he had to rush to Silchar because of sudden demise of his.
Ah.
My senior, he had to leave to Silchar today itself due to demise of his aunt. So can you?
Counsel appearing on behalf of the appellant submits that some time may be accommodated. This is taking into account. You are always taking time. You have been taking time. When do you supposed to do the matter?
Fixed date may be fixed after 2 weeks now. After fixed date may be fixed after 2 weeks.
Let's do after 2 weeks. Hey. Open method I9. Yes. I cannot state it. Then I as an I can allow to speak with
I'm obliged.
judgment in the correct? I as an I can allow to make it a power. So what I am saying.
Obliged.
Then 15.
Yes, what is this? Profile. Hey, to take him to do it. Profile.
Madam, for the petition. Well, a paper publication has been made, madam. And affidavit is also filed.
What is this miscase for?
Madam,
Miscase for what?
this is for paper publication, madam. Applicant state for, completement of minor substitution of respondent number 6 and 7.
What? 22 rule 4,
Yes,
filed within time.
minor,
Who died?
minor, respondent
Who
number 4, minor.
respondent? Sole respondent died.
Yeah, he died.
Huh?
And after that, minor, everybody has been, minor, his heirs and successors have been made parties, impleaded minor. And then again, minor, respondent number 4 died, Suresh Kumar Agarwal. He expired, minor.
Then see if the civilian sole evidence leaving behind. 2010. With the right to, no, this is an application for making all these four, whether this application has been allowed.
Yes, ma'am. This has been
Huh?
announced.
This case allowed,
And
no.
yes. And then, my lord, paper publication was allowed, my lord. And to the extent, my lord, I have given an
No,
affidavit of
madam, I'm asking you whether this application is allowed. This application has not been allowed.
because, my lord, meanwhile, my lord, 4 also died, that is why.
Who died?
4, that's the number.
Which four? Suresh Kumar Agarwal,
Yes, ma'am.
he died.
Right.
What is the suit? What suit is that?
My lord, this is CRP, my lord.
Huh?
This is CRP, my lord.
CRP for what?
For my lord, for setting aside of orders, my lord, that I have not, we have not been included by this, my lord. We have not been allowed to be a plaintiff, my lord. Because when it's so,
Main file to give.
so, plaintiff, my lord, he expired.
Very challenging. Unnecessary matters should be dealt with and finished. P28 2002. But by the Iman painful. Which order? What order you
179.
challenged? What order have you challenged? The courts of Iman and the. What happened to the suit?
Painting, my lord.
How? There's no stay. There cannot be a stay. How can it be pending for the last 27 years?
Because this thing, my lord,
Shocking.
petition has been made by the civil division, my lord.
No, but there's no stay.
In the year.
No, what do you mean? This court arises out of an 47 year order. What a petition is this? So you were directed to implead the trust as a party to this. What is wrong?
Well, trust is not a party, my lord, because recently, my lord, there was a case pending, my lord, another title suit pending.
Huh?
Another title suit was pending, my lord, that has been decreed in my favor, my lord. So in 2022, my lord, that order has not been produced before the Honorable.
2022.
22, my lord.
I'm not concerned. This order is not wrong otherwise.
My lord, there is no trustee at all, my lord.
Huh?
There is no trustee, my lord.
There is an order being passed.
Yes, my lord, that, against that, my lord, you have come.
So here you see there was a revocation deed after the gift deed. Furthermore, new trustees have been appointed on 6/6/84 of the said Hanuman Trust, and Sri Prabhudayal Sarva was appointed as the trustee. So the said trust being a necessary party, the plaintiff was directed to take steps to implead the trust as the party to the suit. But the plaintiff neither challenged this order nor took steps to implead the trust as a party to the suit. Under such circumstances, plaintiff is directed to implead. Okay, now if you don't implead, you may not implead. Let the suit proceed.
My lord, then, my lord, the petitioners will be deprived of, my lord, they are the heirs and successors of the service, my lord. The plaintiff, my lord. Trustee, my lord, these.
Madam, you are challenging an order
Yes.
by which the court directed you to make somebody a trustee,
Yes,
and somebody a party.
Yes.
You being the plaintiff, you may or you may not do it. If you don't do it, you do it equiparely. That's it.
My lord, can I, my lord, produce that order, my lord?
I'm not concerned with
Well,
that.
no,
No,
madam.
madam, let us
Please,
forget about forget about
plaintiff-
any order. Forget about any order. You can produce it before the trial court. Nothing is there. Here, the trial court says that they are a necessary party, and as such, you plead it. You say that the trust is not nothing to do.
Yes, my lord.
You say it before the trial court. You don't do it. That will be decided as in the while framing the issues as to whether they are necessary party, and then they will decide dismiss or allow. It is your-
They are not.
Okay, Leho. This is an application filed under section 115
Yes.
of the Code of Civil Procedure, under Article 227 of the Constitution, challenging the order dated
28,
28
2006,
8 2006,
as well as
2006. Passed in title suit number 179 of 1998 by the Court of the Learned Civil Judge, Junior Division number 2, Kamrup, Metro at Guwahati, whereby there was a direction given by the learned trial court to include the trust, to include the trust, the name of the trust. Include the trust. First. And as well as the trustees to the state suit. The counsel appearing on behalf of the petitioner, who is the plaintiff, submitted that that the trust in question is not a necessary party and has nothing to do with the plaintiff number 2. And as such, this order dated 28/8/2006 is required to be interfered with. This court has duly also taken note of that some of the respondent
please tell
in the instant application, to the instant application,
as well as the tenant, my
namely Sri Deendayal Agarwal,
lord,
had expired And on the basis of an order passed by this court on 2/5/2014, his legal representatives have been substituted. This court further takes note of that the plaintiff being a dominus litis to to the suit has liberty to implead or not implead a party to the said suit. If the said, if it is observed that the learned trial court, if it's observed that if the plaintiff does not implead a necessary party or even a party who is essential for the adjudication of the said dispute, the plaintiff shall the suit, the said decision of the plaintiff could be at its own peril. Considering the above, considering the fact that the petitioner herein who the plaintiff have assailed the order dated 28/8/2006, this court is of the opinion that there is no requirement for the plaintiff to implead this court is of the opinion that the plaintiff opinion that there is no requirement for interfering with the said order that impugned in the instant proceedings. However, it is observed that if that the plaintiff would be at liberty to implead the trustees, it is further observed that at the trial of the suit, the learned trial court shall decide the same without being influenced by the order dated 28/8/2006. Therefore, matter. LCR was called for. Huh? The LCR which have been called for, be forthwith returned to the learned trial court. Taking into account that the petitioner is represented, this court directs the petitioner, the trial court here now, to appear before the learned trial court on 16th of June 2025. The registry shall ensure that the trial court, the records are received by the learned trial court on the dates so fixed herein above, prior to the dates so fixed.
Item 16.
None appears on behalf of the appellant on call. It is seen that the appellant has not been represented for the last 3 days. In fact, by the order dated 9/4/2025, this court duly observed that if the appellant is not represented, appropriate orders shall follow. So taking into account that the appellant is not represented, the instant appeal stands dismissed for non-prosecution.
17.
None appears on behalf of the appellant on call. it is also seen that this court by an order dated 6/5/2015 had issued notice. Thereupon, the matter had come up on various occasions. But the applicant had not taken steps as regards the respondent number one. From the above, it appears that the applicant have lost interest. Applicant have lost interest in the instant proceedings, for which the instant application stands dismissed for non-prosecution. Taking into account that the instant application is an application seeking condonation of delay, and the instant application is dismissed for non-prosecution, the accompanying appeal so filed cannot be entertained as it is barred by limitation.
This application is for provisional delay. You know, we did not take steps for some of the respondents. Substitution was supposed to be done. And in the meantime, you know, the appellant's it's expired. Last
When?
about 6 months back, because on last 19th of February, I could contact in his telephone number and his daughter and then she told that they are not interested to pursue the case.
Oh,
As he has expired time for
then what is this point? Be interested in fighting prior to that?
prior to that, he could not provide the correct address and the legal name of the
Then
legal
how do you take care of this? Tell me, in 2016, you are filing of an RSA of 2015, nothing is being done.
2021, I served the
Then why you are making unnecessary this former respondents of
Now on 19th of
many persons?
last 19th of February, I could come to know that he has expired.
Huh?
Last 19th of February, I could come to know that he has expired. And his legal heirs are not interested to,
Not interested.
they are not.
The learned counsel appearing on behalf of the applicant submits that the appellant, who is the applicant hearing, had expired on 19th, had expired around 6 months back, as he could come to learn from his legal representatives, from his daughter. But the applicant's legal representatives are not interested to pursue the instant appeal. Considering the above, the instant application by seeking condonation of delay is dismissed as the same had abated. As the application for condonation of delay had been dismissed, the accompanying appeal, second appeal so filed cannot be entertained as it is barred by limitation. You give your name, huh? Okay. Third, RSA with everybody did AD card nor received notice has been received from the response till date. Steps by usual procedure is the NCR. What is this IA for?
I for the stay, probably it was granted at the time of not value worship, but perhaps it's possible for stay.
Huh?
For stay. Stay granted.
They have not taken first steps upon respondent number 5.
That's what we have taken, but
Okay. steps by usual.
not taking
You have not taken steps by usual.
Second. Like large.
Huh?
Usual process. Second.
Counsel appearing on behalf of the. When did you take steps?
Steps.
Now you have to take fresh steps. Last time steps taken on 22.
Yes.
And who is response number 5?
For what?
Huh?
Doctor, you know. The legal character. Plaintiff number 2.
Legal error of
Plaintiff number 2.
response number 5.
Yes. Oh, it's here. Here.
Who is appearing for one? Anybody who is appearing for 104? 104, no. Huh? This address, nobody will get it. Resident of Nazira, my goodness. How will you have Nazira is so small? Huh? Here also, if you give port number 14 also and give the name of any person, nobody will find it. You're putting
I mean, I'm taking.
the only counsel appearing on behalf of the appellant submits that you will assert in the proper address of the respondent number 5 and take fresh steps to stop. The appellant is directed to take fresh steps upon the respondent number 5 by ascertaining the address within 16th of May 2025. To stop. If such steps is not taken, the matter be listed before this court again. The steps be taken by way of registered as well as usual. 20. Right. Address. Not necessary. Take step. 20. What is this SAO business?
Order was passed. Respect of an application filed under order 21/19. The application was filed by.
Huh?
That was allowed. The appeal against the appellate court's order they have filed.
What order they have come?
Against the appellate court order, my lord, allowing my application under order 21/19. I was dispossessed from my room in execution of a decree in a suit, wrongly disposed. The plaintiff appeared, filed his objection. He said that my room and the decretal room is different.
It's okay. Let us not go on to that. First of all, tell me, you filed an application under order 21 rule 99. That was allowed.
First, it was rejected. Thereafter, on appeal. In between, there was a round of litigation before the Honorable Guwahati High Court also.
Kindly come to the point whether that application was allowed by the executing court or not.
Executing court, it was rejected.
Rejected. So the first appellate court allowed it. Against that, this is filed. On that, I'm asking you this.
Right.
So you are paying for the others?
I'm appearing for the respondent number 1.
Service completed? Okay. Service report has been received in respondent and the same has been placed before you. Taking into account the office note dated 29/4/2025, the service upon the respondent number 2 is complete. This note further takes note of that the judgment that the instant appeal is being filed against the judgment and decree against the decree passed Miss Appeal number 28 of 2019 dated 26/2023 was taking into account the registry is directed to re-register the instant appeal as an RSA. LCR received. Know that. That is why it's actually an RSA. RSA. And thereupon, list the matter for hearing in the usual course. List the matter where liberty given to both the parties to file application for early hearing.
21.
What is this?
We have the same thing, you know, that,
Section 8. Section 8.
My application. The impugned order is at page 49, starts. Secondly, what's it, the finding is at page 53. Second paragraph. Of the agreement, I think of crystal clear that the same clause of 16 was inserted in the agreement as per Arbitration Act 1940. Whereas the defendant in his petition mentioned the provisions of 8(1) of the Arbitration and Conciliation Act 1996.
As Mr. D. Chaudhary, the learned counsel appearing on behalf of the petitioner. Pusto. None has appeared on behalf of the respondent on call. Pusto. This is an application. The supervisory 115 or 227. The supervisory jurisdiction of this court has been invoked, challenging the order dated 2/2/2023, passed in Midday case number 37 of the 2023, arising out of title suit number 45 of the 2020. From a perusal of the impugned order, it is seen that an application was filed that pursuant to a suit being filed by the respondents herein as plaintiffs, which was registered and numbered as title suit number 45 of the 2020. The petitioner herein, who were the defendants, filed an application under Section 8 of the Arbitration and Conciliation Act 1996. This court duly takes note of that by an order dated by the impugned order, the said application has been rejected merely on the ground that in clause 16 of the agreement, there was a mention of the Arbitration and Conciliation Act 1940 and not 1996. This court have duly taken note of clause 16 of the clause 16 of the agreement, which is reproduced herein under paragraph 33. From a perusal of the page 33, paragraph 16. From a perusal of the above clause, from the above quoted clause, it would be seen that the arbitration was to be held in terms with the Arbitration Act 1940, including its statutory modification and reenactment. The said expression used in inverted comma, including its statutory modification and reenactment, inverted comma closed, would include the Arbitration and Conciliation Act 1996, taking into account that there is total perversity in the order passed by the learned, taking into account that the impugned order have been passed without proper application of mind, this court interferes with the impugned order dated 2/2023, passed in Midday case number 37 of the 2023. it is further relevant to take note of, as the learned trial court not consider the said application in accordance with law, comma, according with law, full stop. And the learned trial court is an authority within the is a judicial authority, as mentioned in section 8, comma, it is the opinion of this court that the instant application that the matter that the learned trial court should be that this court should direct that the court is that this court shall the court is required to remand the consideration of the application beginning Ms. A case number 37 of the 2023 by the to the learned trial court, that is the court of the civil judge in Julie, number 1, Kamrup Metro at Guwahati, for a fresh decision on the application and filed under section 8 of the Arbitration and Conciliation Act 1996. This court accordingly restores the Ms. A case number 37 of the 2023 to the file of the court of the learned to the file of the learned trial court, that is the court of the so and so, in title suit number 45 of the 2020. This court further takes note of that by the order dated 15/3/2023, the further proceedings of title suit number 45 of the 2020 was stayed. The stay order is vacated, and the parties herein who are duly represented, the parties and the petitioner herein, who is with the defendant in the suit, who is duly represented, is directed to appear before the learned trial court on 12th of June 2025. The learned trial court, before deciding the application under section 8, shall issue notice to the respondent, to the plaintiff, and then proceed and decide the said application in accordance.
22 and 23.
Huh?
Out of admission, my lord, and he is
Who is out of station?
undergoing medical treatment, my lord. My lord, I have a appointment.
The
today
applications and
medical.
all those should be prepared by the applicant. Seeking amendment of the written statement by the year which
My
was.
lord, this is very serious.
You have filed objection?
Yes, madam. Thank you, madam. 18 to order is there, madam. This is honorable court, madam.
Huh?
18 to 25 order is there.
Hang on.
18 to 20.
18-2.
Yes.
A very serious and was speaking with several examiners have been taken. The appellant on the ground of protection and employment.
Direction for permission communication on next date, but on the next date, my lord, the council appeared, my lord. And my lord, he can excuse that he will file an affidavit in reply. But when there is no, where is the provision my lord, for having affidavit in reply in an objection, my lord? In the amendment petition, we have filed an objection, my lord. And my lord, the last objection, my lord, the time is taken on the ground that against the objection, they will file a reply. My lord.
Now, have you filed a reply?
They already filed, my lord, already filed reply.
Huh?
Already filed reply, my lord.
It has already been filed.
Already filed.
However, it is not on record. Okay. Now,
Now, my lord, this amendment is filed by this second table stage, my lord. And my lord, this is against the order 617, my lord. There is no explanation, my lord. The absence of due diligence was there, my lord. Only to delay the disposal of the RSA, my lord. RFA is filed after 3 years of the judgment.
What? What are these substantial questions of law? Laughable, which have been framed. Isn't it?
The first appeal is my lord dismissed on the ground of failure, my lord. That question,
Under section 5.
yes, my lord. It was filed after 3 years of the judgment.
Substantial question law arises as to whether the first appellate court correctly adjudicated upon and decided the application filed under section 5.
My lord, I am Larson, my lord.
Ah.
My son is admitted in the hospital, my lord. I have a appointment slip, my lord, and hospital, my lord.
It is day before yesterday. And that too for general repeat consultation. Why you are saying that he admitted for admitted? He is not admitted.
Oh, my lord, appointment slip, my lord.
Huh?
This is appointment slip, my lord.
This is that Tamil Nadu.
Yes, madam.
Tamil Nadu.
Yes, madam.
Why has he gone to Tamil Nadu? Oh. Tamil Nadu can't help it. Okay, change your counsel. Do it well. This type of matters can't go.
That petition under section 5 was rejected. Against that matter, this second appeal.
So what has happened now? Who is the plaintiff?
And for the claim,
Who is the service not done against whom? Huh?
three objects, the performer was all there.
Why do we require the performer number 3? Why do you need?
That's it.
We don't require the performer. Just strike off. You are paying for 1 and 2.
One.
2,
Two service company. Two service company.
the 3 not necessary.
Actually, no,
Why do you require 3? Why do you want 3?
that's it. You are the party.
So you are a defendant. You have no business with him. You have no claims against him. Did you file a counterclaim? of its to directed to file a fresh memo of parties before the registry of this court and file an affidavit of, and we are registry and the registry shall make necessary correction of the details of the cause title and also update the same in the CIs. CIs. It is also taken note of that the LCR have not been received. From where? Have not been received. Full stop. The registry shall ensure that the shall ensure that it will have not been received. Full stop. It is further taken note of that by the order dated 2024, the registry was directed to issue a reminder for transmitting the reminder to both the courts below for transmitting the reports without further delay. Under such circumstances, the registry shall ensure that the reports are available before the court. That under such circumstances, this court fixes the matter of final disposal on 10th of June 2025 at 2 p.m. The registry shall ensure that the records are available on that date. Interim order passed earlier shall continue till then.
Interim order is there. All right.
Now, that instruction but not obtained, Lord.
What did I ask?
But whether the but additional written statement has been filed after the amendment petition is allowed by the trial court. That was the query was made by the court. Now, that instruction I have not available today, Lord. We have already intimated, Lord.
You don't have phone number.
Yes, I think the phone number, Lord, I have.
I have got the instruction. The response of my amended claim, they have already filed their written statement on 8/8/2020.
I wait.
2020.
2020. Then what do you mean? Huh? What do you mean?
But
Obviously, that is why I asked when there is no stay,
yes,
you have to mention file it. And once you file it, what it means?
the input order also been filed. at
And you
page
filed it on when?
Page 74 is the input order.
Very wrong.
Page 70.
Why the amendment was allowed?
Lord, the number of the scheduled land
Ah.
has been changed by way of amendment.
Oh, very good.
Now, as the unregistered cell deed that has been challenged before the trial court.
Now it's a registered one.
No, unregistered.
So why should we interpret? Why the amendment was made?
The amendment was sought regarding the boundary of the scheduled land. Southern part of the land. Actually, it was
Clerical error, Lordship, my colleague. 34 was 18 us to 70. Instead of
So you want to bring the rectification deed.
rectification did already.
You want to bring the rectification deed by way of amendment,
By
as well as also correction of the DAG number. That's all.
boundary of.
If the deed was not unregistered and there is no rectification deed. For amendment, Lord, there should be a rectification deed. Unless the rectified deed is there, how they can, Lord, amend the, Lord, the deeds? Saying that number should be so and so, so.
Does he have a sale deed?
Unregistered sale deed.
So unregistered sale will always have an unregistered rectification deed.
Whatever it will be, what that unregistered sale deed should be rectified.
Am I to consider all these things before the trial court to decide? Each very thing you have must have taken in your additional witness statement.
I think that's clear.
Heard Mr. So-and-so, the learned counsel at hearing on behalf of the petitioner. And Mr. So-and-so appears on behalf of the respondent. Is an application filed decided by invoking the supervisory jurisdiction of this court challenging the order dated 19/9/2023 passed in music case number 90/2022 in connection with Title 5/2021 by the Court of a Civil Judge Senior Division Registry, whereby the application filed under sections order 6-17 of the Code of Civil Procedure 1908, for short, the code was allowed. It is relevant to take note of that the said application, by way of the application seeking amendment, the petitioner, the plaintiff, sought for amendment to make certain rectification and what amendment to incorporate subsequent events pursuant to the filing of the suit, which was allowed by the learned trial court. And such application was allowed by the learned trial court by the impugned order. It has also been brought to the attention of this court that pursuant to the impugned order, the amended claims have been filed. And the petitioner herein, who are the defendants, have also filed their amended additional written statement on 5/11/2008, 5/8/2024. Taking into account the above, this court finds no grounds to interfere with the impugned order dated 19/9/2023, impugned in the instant proceedings, which the instant petition stands dismissed.
26.
Who is respond number 567?
It's 567. The legal representative of the attorney for that.
Huh?
That the legal representative of the alleged attorney. This, the main ground of the suit is that his attorney holder, purported attorney holder, he forced this attorney on behalf of the appellate.
So he's the main defendant.
Yes, yes.
So here service is not complete, na?
Yeah, so your lordship may kindly allow us to take those key steps. Because there is some urgency, they are trying to dispossess us.
You are appearing for whom? Who are appearing for these people otherwise? Number 8.
I'm looking for 8, 9, and 10.
8, you cannot appear.
Because
5, 6, and 7, 5, 6, and 7.
So what has happened to the appellate? They are telling us that they something. But I did not find any of their addresses, any of the people.
5, 6, 7. 5, 6, 7. Not
Well,
understanding.
that
So
is
many parties. Why? What is this, Mr. Olaskar, we have done? First is appellants, you have made them. Then comes respondents, then again applicants, then comes respondent. Now this 5, 6, and 7 is Ujit Das, Ujit Das, Ujit Das. Okay.
Yes.
So you want to take first steps?
Yes, by way of trustee.
Mr. Olaskar, the learned counsel appearing on behalf of the petitioner, applicant submits that there is emergency in the matter for which he may be permitted to take fresh steps upon the respondent numbers 5, 6, and 7 by way of the state routed through the registry of this court and file an affidavit of service on the proposal state. Taking into account the above, brief this matter again on 2nd of June 2025. In the meantime, the applicant's hearing shall is given the liberty to take steps by way of the state routed through the registry of this court upon the respondent numbers, opposite party numbers 5, 6, and respondent numbers 6, 5, 6, and 7 by way of the state routed through the registry of this court and file an affidavit of service. Yes, what are these? So many.
Sole respondent lordship.
Huh?
We have filed substitution for sole respondent. That is 2023.
How many days delay?
There is delay lordship. Later on, we have filed the condemnation application. The respondent are objecting.
How much is the delay?
Delay lordship, as per Somoto exemption, there is no delay, only 22 to 27 days delay lordship. If we count from 1/3/2022. It was informed to the court by the respondent.
When did the person die?
Lordship, he died on died on 20. Date of death 12/5/2021.
By 2021. Okay, then when did you file this application?
IA informing their
14/11/2023.
yes.
Huh?
14/11/2000 no lordship, or it is on 25/2020.
When did you file the order 22 rule line?
Order 2 rule 9, we have filed on lordship 26/2022.
Huh?
26/2022.
21/6. 28/6.
IA number 2023.
28/6. 28/6/2022. Okay. Very within time, the limitation business. Isn't it?
Yes.
What is it? What are you objecting?
You're objecting because the date of knowledge or the regard to the knowledge of the death of the appellate, respondent, which they have stated is what we are disputing. We have brought on record a certificate which shows that their own person were aware and they are residing they are just my
I'm
neighbor.
asking you, did he die on 12/5/2021?
21 he died.
Did he file this application on 28/6/2022?
Hello.
That is two facts.
Right.
Now, as per the Supreme Court judgment on 12/1/2012, 2022.
2022, Somoto 03/2020.
That time was extended till 28 to 2022.
Till 20, not 28 till. It says 3 months from there.
And it was filed thereafter. It was filed
So what? From there, 90 days will come.
there 19. My lord, 1/3/2022, the period of limitation start. If anything to be done, then it is to be done from 29. My humble submission. ma'am. From
Why so
1/3
many applications?
Lordship, appellate number 3
My lord,
also died.
these three
How
items
many
I have no
people died?
objection.
sole respondent died, lordship, 3 applications, then appellant number 3 died, 3 applications.
My lord, these three I may be allowed, I have no objection. It's I 3388, 3390, 3392. But that may be taken up for, these are with regard to, so bring on record the legal errors of appellant number 3. To that regard, I have no objection. This may be allowed.
Which one?
3388, 3390, 3390.
28,
3390, it's setting aside abatement, and 3390.
9,
9. These three
What-
may be allowed, my lord.
what is 3393?
3393 is the limitation application in respect of the respondent, sole respondent. Regard to delay in filing the setting aside abatement. At least these three, I therefore, my lord, please to hear me out on that.
Huh?
These three, I have no objection. And regarding that issue with regard to, if my lord says that on from 29/5/2022, the period remains, that point, I'd like to take my, but at least these three can be disposed of today.
No, this 6.
Okay, so my lord, these three I have no objection. Now, with regard to the suo motu, the judgment of the Honorable Supreme Court, the period of exemption was till 15/3/2020 till 28/2/2022.
Whether the appeal has been admitted,
Appeal has been ended.
who informed the, when did you appeal?
I informed this court on 1/6/22. I filed the petition.
After
Oh,
what year?
you informed the court on 1/6.
Lordship, thereafter we filed.
Eh, look.
After what?
My lord,
we informed.
Not necessary.
No,
No
my lord,
more.
just.
No more, no more.
My lord,
You-
even if I submitted, I informed this on court whether that can be a date of knowledge with regard to this.
Absolutely.
And then, my lord, what they say,
This is the latest judgment of this.
my lord, only one submission. Then what they are submitting, or what they have stated in their application for condemnation of delay, is that only when the council, learned council informed them regarding the death of the sole respondent, they have taken the necessary step. What my humble submission before this honorable court, the respondents are residing over my land, and I was residing the adjacent property, on the adjacent property. So their date of knowledge is same on 12/5/2021. In fact, the appellant number 3A, who is sought to be substituted in I 3388, sees a signatory seal signed in respect of a certificate with regard to my death. The sole respondent.
That must be the reason he died.
But that, whatever may be the reason, my lord, with regard to, my lord, your lordship's own judgment is this. No, my lord, this honorable court has passed an order with regard to the substitution, wherein this honorable court has told that there are two grounds in which a application for section 5 can be allowed. One is with regard to the party has to show sufficient cause. If the party fails to show sufficient cause, that this honorable court is not obliged to condone that. This honorable court has passed the order. And subsequently, even if there is a sufficient cause is being shown, then the discretion is upon this honorable court whether such delay is to be condoned or not. What my humble submission is that, thus, apart from the submission, if my lord takes up the application for condonation of delay, whether the application, whether the application for condonation of delay does not show any sufficient. Because that application has to fortify the submissions with regard to the delay.
I was in Lila file to this. About the second file to. Lila file, Wakala from file. Sama file to puno pa niyo. Hindi, file to. We have argued a lot. Let us now dispose of the RSA. allowing the RSA matter finish, argument done. For an application under section 5, I don't allow so much of argument. We have heard too much.
My lord, I only submitted. with
We
regard
say enough, hearing done. On whether the declaration of right title in interest of the plaintiff over the suit on the basis of exhibit 2 and 3. Certified copy of the chitta and certified for being void of the name of the father in the state exhibit 2 and 3. The decree given on the grant of chitta and Roman.
my lord.
They are saying their paternal property and their father's
Yeah,
name is not there.
By this order, this court proposes to dispose of the following, the six applications. The appellant. The order for pursuing the suit. The instant appeal has been filed. Under section 100 of the Code of Civil Procedure. Challenging the judgment and decree dated 2/8/2017 entitled appeal number 6 of the 2015. This court, by an order dated 3/11/2017, admitted the appeal by formulating a substantial question of law. Thereupon, the sole respondent appeared before this court through the counsel. On 19/5/2022, the sole respondent, while an application filed under Order 22, Rule 10A of the Code, which informed this court that the sole respondent expired on 12/5/2021. The said application was disposed of. The said application being IAC number 1690 of the 2022 was disposed of by an order dated 13/6/2022 by duly recording that the learned counsel who appeared on behalf of the sole respondent had duly performed his obligation as obligated under Order 22, Rule 10A of the Code, and thereby bringing on record that the appellant, that the full respondent expired on 12/5/2021. Upon such information being gathered, the information being provided, two applications were filed by the appellants. Which were registered and numbered as applications were filed by the appellants. That is an application under Order 22, Rule 3, 4, and an application under Order 22, Rule 9, which were registered and numbered as IAC 2024/2022 and IAC 2023 of 2022. While these two applications were pending, the appellant number 3 expired on 10/6/2023. Accordingly, 3 applications were filed on 15th of November 2023. Being applications under Order 22, Rule 3, Order 22, Rule 9, as well as an application under Order 20, Section 5 of the Limitation Act 1963 for condoning a delay of 6 days. The said applications were registered and numbered as IAC 3392 1990 2023, IAC 3390 2023, and IAC 3388 2023. Taking into account an objection being raised by the counsel appearing on behalf of the respondents that there was a delay in filing the application under Order 22, Rule 3, Order 22, Rule 9 for setting aside the abatement of the sole respondent. Another application was filed by the applicant, which was registered and numbered as IAC 3393 of 2023, seeking condonation of delay. It is seen in all these applications that in respect to the application being IAC 3393 of 2023, an objection has been filed by the opposite parties numbers 1A and 1B. Wherein it has been mentioned that the wife of the appellant number 3 knew about the death of the sole appellant in as much as she had certified the death of the appellant number 3.
Death of respondent.
Right?
Death of respondent, certified the death of.
The respondent number 3. And wife of the appellant number 3 had due knowledge about the death of the sole respondent, as she has certified the death of the sole appellant. Mr. A.K. Wright, the learned counsel appearing on behalf of the respondents, submits that he has no objection in respect to the substitution, setting aside of the abatement and substitution of the appellant number 3. But he has objection as regards the condonation of delay. In filing the application for setting aside the abatement of the sole respondent on the ground that the cause so explained, sufficient cause so explained, on the ground that the grounds so explained do not come within the meaning of sufficient cause as mandated under Section 5 of the Limitation Act. Yes, others may go. Let me finish up this. In order to decide the said objection so raised by Mr. A.K. Wright, the learned counsel, this court finds it relevant to take note of a recent judgment of the Supreme Court in the case of Om Prakash Gupta, alias Lalua versus Satish Chandra, bracket, now deceased, reported in 2025 SCC Online SC 291. In the same judgment, the Supreme Court dealt with the provisions of Order 22, Rule 10A of the court. And observe that the same provision casts the duty upon a pleader appearing for a party to the suit to intimate the court about the death of such party. It further provides, the Supreme Court further observed that the same provision further provides that once the court is informed by the pleader of the party that he is no more, the court, in inverted comma, shall notify the opposite party of the death. Supreme Court opined that a straightforward interpretation of this rule would suggest that the court is obligated to issue notice to the other party is indeed mandatory. Nonetheless, this obligation may not arise in all circumstances. The Supreme Court observed that one notable exception could be that when the information regarding the party's death is conveyed to the court in the presence of the opposing party pleader or is documented by the court in the order sheet. In such case, if the pleader of the concerned party and consequently the party itself have already been notified, issuance of further notice from the court could not serve any substantial purpose other than being an exercise by way of abandoned caution. It was further observed by the Supreme Court that that other than the 28 and 29 of the state judgment being relevant, it's reproduced hereunder. In the instant case, the sole respondent was duly represented. On 12/5/2021, the sole respondent had expired. And as such, it was an incumbent duty upon the counsel representing the sole respondent to inform this court in terms with Order 22, Rule 10A, forthwith. However, it was only informed by filing an application on 19/5/2022. And this court duly recorded the same on 13/6/2022. It is further seen that immediately thereafter, the two applications were filed, being IC number 2024 and 2023/2022. 2023, 2022, and 2023 of 2022. Considering the above, it is the opinion of this court that the delay in filing of the application for setting aside the abatement of the sole respondent is required to be allowed. And accordingly, this court orders so. This court further takes note of that the right to pursue an appeal against the legal representatives of the appellant of the sole respondent continues pursuant to the death of the sole respondent. And as such, it is the opinion of the court that both the applications seeking setting aside of the abatement as well as the applications seeking substitution of the legal representative of the respondent number 2 of the respondent number of the sole respondent is required to be allowed. Accordingly, this court substitutes the sole respondent substitutes the opposite party number 1A and 1B of IAC number 2024 of the 2022. As against the sole respondent. This court further takes note of that who is the appellant plaintiff? Taking this court further takes note of that the appellant number 3 having expired and the grounds and reasons shown in the application being IAC number 3392 of the 2022.
3393.
3390.
393.
3380.
Appellate, Your Lordship, all the later ones. Yeah.
3388.
388.
Grounds and shown in the application seeking condonation of delay of 6 days being in accordance being sufficient, the causes shown in the application seeking condonation of delay for 6 days being sufficient. This court allows the state application, thereby condoning the delay in filing the application for setting aside the abatement of due to the death of the appellant number 3. This court further takes note of that the right to pursue the appeal pursuant to the death of the appellant number 3 continues as regards the appellant continues in favor of continues in favor of the legal representatives of the appellant number 3. And accordingly, this court substitutes the applicant numbers 3A, 3B, and 3C against the respondent, against the appellant number 3. All the interlocutory applications accordingly stands allowed. The counsel appearing on behalf of the appellant shall file a fresh memo of parties before the registry of this court within 7 days from today, and the registry shall, on the basis thereof, make necessary corrections in the cause title and update the same in the series.
applications were filed in the year 2022 and 2023. So we write 3.3A, 3B, 3C. Now CIS system is taking up only 3.1, 3.2, 3.3. So if your lordship allow them to be included as
A substitute, then here we have to make 1.1.
amended prostrated, I will make there.
No, I will make it 1.1.
1.2.
Take it up 1A, 1B to 1. Applicant, the respondent numbers 1A and 1B
May be considered as
are substituted as against the sole respondent and arrayed as respondent number 1 and 1 to the accompanying appeal. A2 Diva, the respondent number, applicants number 3A, 3B, and 3C are substituted against the appellant number 3 in the accompanying appeal and arrayed in substituted against the appellant number 3 and arrayed as appellant number 3.1, 3.2, and 3.3 to the accompanying appeal.
So that, in respect of item 37, one of which should be listed as an admission that has entered defense for the sole respondent. Now they are enjoying the stay order, and my student stay. In fact, one of them take up as an admission item any day, but next week, my.
Item number 37, with the service being complete, leaves the matter. What is the matter about?
In fact, my lord, after the determination of the lease, they are still in occupation of the, my lord, land, my lord, my.
Landlord, tenant, or what?
Yes, they were tenants, my lord. In fact, I'm sorry. Look, I'm a bit nervous.
Mr. Rai is also laughing, landlord, tenant. I cannot speak more than that. If the year service is complete, leave the matter on some.
Lordship, in item 42, I have come from Delhi, my lordship, it was fixed for today.
With?
Item 42, my lord.
Ah.
Was fixed for a.
What to do? Get hold of Mr. Rai.
Next,
Unnecessarily, he spoiled my time.
My lord, 37
next
of-
week it may be
37, my
fixed.
lord, next week, well, that's admission item.
Item number 42,
Next week, my lord.
On 8th, my lord. 8 is Thursday.
no Thursday. 9.
Okay. Like, as an admission item. If you.